thank you all for your attention today, coming to this important meeting, and for those who have come to testify today. This meeting is being recorded, so I would encourage members and guests to please silence your cell phones and electronic devices. Would the Secretary please call the roll?
Chairman Kauffman.
Present.
Delosier. Dush.
Here.
Gillen, leave. Grove. Kiefer. Keller. Clunk. McKenzie, leave. Maloney, leave. McGinnis, leave. Menser.
Here.
Nelson, leave. Rader, leave. Topper.
Here.
Chairman Galloway. Cephas.
On leave. Oh, you got it.
Deasy. Donatucci. Leave.
Leave.
Kruger Brannigy.
Here.
McNeil.
Leave.
Miller. Mullery. Nielsen.
Here.
Ravenstall.
Leave.
Snyder.
On leave.
Thank you very much. And in addition to the members of this committee, Representative Donna Oberlander, who's a member of the House Republican leadership team and has legislation that has been referred to this committee on this topic. She's here today, and I invited her to join us here for this hearing. So today we will be discussing harassment and sexual misconduct in the workplace. I consider this topic to be very important, so I want to take a very deliberative approach to this legislation. There are many pieces that are before this committee and before other committees of the House. This hearing is intended to give the committee an overview of the issues related to this topic so that we can lay the groundwork for future discussions. We do have a very robust agenda and quite a few great folks to give testimony and their input. And so many of you who were at my hearing last week, I was very laid back and relaxed about the testimony and the latitude which I gave folks as they asked questions and took 15 minutes to ask their questions. Well, today will be very different. We are going to have a very structured approach, so as you are formulating your questions for the panels who are before us, please be thinking very narrowly and focusing your questions, because there are many folks here at the tables who have questions, important things they'd like to ask these folks, and I want to make sure that we have a wide array of questions that are asked from different folks here at these tables. So I want to thank you, First Ladies, for being here today, and I look forward to your testimony. And this first panel is going to be focused on victims of workplace harassment and sexual misconduct. We have with us some of the folks who assist victims, and they're going to discuss the challenges victims face, as well as the best practices for encouraging and responding to victims. Joining us now at our first panel, we have Donna Greco, Policy Director of the PA Coalition Against Rape. We have Juana Nikita. Nikita, I apologize for the pronunciations. I'm a work in progress. Counselor for Nova Network of Victims Assistance, and Terry Fromson, Managing Attorney of the Women's Law Project. Now, I have no designated orders, so you can go as you like or as I had called your name. You're welcome to begin.
Thank you, Chairman Kauffman and Galloway, and members of the committee for convening this hearing on sexual harassment and misconduct in Pennsylvania's workplaces. My name is Donna Greco. I am the Policy Director of the Pennsylvania Coalition Against Rape, and very grateful to be here today, and thank you for bringing this committee together to discuss this important issue. I've had the privilege of working to end sexual violence and to support survivors for over 20 years, and much progress has been made, but of course there's still so much to be done. Sexual assault is at the forefront of the news, of pending legislation, and our public conversations, thanks to the courage of so many victims that are coming forward, as well as many of the panelists and legislators in this very room. And more victims are beginning to feel comfortable, and that is wonderful news. But we also are seeing a backlash of scrutiny unfolding against victims, despite what the research tells us about false reporting being so very low. We continue to face barriers to taking action, especially when offenders are in positions of trust, authority, and power. We sometimes misplace our focus on the actions of victims, whether they reported, whether their actions line up with the way we think they should feel, why they waited so long to come forward. When real change requires us to place our focus on the actions of persons causing harm, where they received messages in their lives that that behavior is acceptable, and how our workplaces may intentionally or unintentionally allow the actions to go unaddressed. We all know that sexual harassment is pervasive and unlawful. It encompasses a continuum of acts and behaviors. Its effects reach beyond victims, although that will be the focus of our panel today. But it reaches coworkers, it reaches families, and our greater commonwealth that misses out on the productivity and innovation that is undermined by sexual harassment. 81% of women and 43% of men have experienced sexual harassment at some point in their lives, and up to 85% of women and 19% of men have experienced those assaults in the workplace. Victims of sexual harassment are often caught in catch-22 situations with virtually no good outcomes. Endure the harassment or lose the client. Endure the harassment or get demoted. Endure the harassment or lose your job, or keep your job, but then be forced to find a way to avoid the harasser and to cope in a hostile environment, or report the harassment, but then risk retaliation by your coworkers and sometimes by your employer. These are very real struggles that are backed by research that shows retaliation is experienced by employees who speak out about mistreatment. And despite the prevalence of sexual harassment, we know that most people suffer in silence. In fact, 85% of sexual harassment victims never file a legal complaint, and 70% never alert their employers about what has happened to them. Instead of reporting, most victims quit their jobs or find ways to alter their schedules and their physical environments to avoid harassment. The most common barriers victims experience are really rooted in the fear and shame that many victims experience, that no one will believe them, there won't be any action, they'll be blamed for causing the harassment, they'll face humiliation and social retaliation from their peers, and they will face professional retaliation. Sexual harassment can derail a person's psychological, physical, and economic stability. It's been linked in the research to post-traumatic stress disorder and major depressive disorder. It's also been linked to serious physical health struggles, such as chronic headaches, interrupted sleep, gastric, respiratory, and cardiovascular problems. Sexual harassment also undermines the economic stability of victims and their families. Studies show that women report significantly greater financial stress and career disruption as a result of sexual harassment. They are 6.5 times more likely to change jobs to escape further harm. We can all agree that no one should have to choose between their livelihood and their safety. Every Pennsylvanian deserves a workplace free from harassment, assault, and abuse. Whether they're serving tables, fighting fires, building roads, trying cases, treating patients, caring for children, or making laws. Our workforces, businesses, and communities thrive when every individual is able to reach their full potential in environments where they're respected and equitably treated. We have an unprecedented opportunity to make this a reality throughout Pennsylvania. PCAR applauds bipartisan efforts and the efforts of this committee in coming together today to really look at sexual harassment and what we can do to support victims and also to stop its occurrence in the first place. While ongoing assessment is necessary, there are also action steps we can take today. PCAR recommends trauma-informed approaches that are reflected in many of the legislative proposals before your committee in the larger legislature. We know that strengthening and expanding workplace policies will help bring everyone onto the same level and create transparency in how to make reports and where to get services and what their rights and resources are. Strong policies also ensure that fair, impartial, and thorough investigations are conducted and the rights of the accused are honored, as well as the rights of the victim, to really make sure that that process is swift and connects people to the resources they need both in the workplace and outside of it. We encourage employees to report sexual harassment through regular training and by creating multiple reporting avenues. Reporting mechanisms must be impartial and seen as safe and resources for all parties that are involved. To these ends, we feel that reporting mechanisms must be staffed by trained individuals who are trained in sexual harassment and its prevention, and that those staff are seen as neutral resources to all parties. We support formal collaborations across workplaces and community-based organizations, such as counselors that support victims and survivors. You'll hear from Juana today, as well as legal advocates who can really help victims walk through their rights and resources. We support policies that elevate and safeguard victim privacy and safety and choice. All or nothing approaches are often well-intended, but don't fit for every victim and survivor, given the uniqueness of their lives. We also support policies that enable victims to access a range of options, workplace and community-based, civil and criminal. Again, not one or the other. We need a scope of resources for individuals that are traumatized by sexual harassment. And finally, we support policies that implement best practices in prevention. There is a way to prevent sexual harassment. There's emerging science and evaluation data available to us that really point towards civility and bystander intervention training in workplaces. They're showing tremendous promise in equipping employees with the skills that they need to recognize harassment and say something and interrupt it and report it. It's really serving our entire workplace when everyone is equipped with those skills. Lastly, I wanted to point that trauma-informed practices are not necessarily at odds with fairness and impartiality. In fact, we can often measure the well-being of our larger workforce by how we treat victims when they come forward with a complaint. Thank you for inviting me and PCAR to be here today with you. We look forward to working with the committee and fellow panelists and the General Assembly in strengthening our laws and resources around sexual harassment. Thank you very much.
Good morning, Chairman Kauffman, Chairman Galloway, members of the House Committee on Labor and Industry. I am grateful to you for convening this hearing on workplace harassment and sexual misconduct, and appreciate the opportunity to share my comments today. My name is Juana Nikita. I am a licensed professional counselor at the Network of Victim Assistance, the Rape Crisis and Comprehensive Victim Service Agency for Bucks County. NOVA is a private nonprofit community-based organization whose mission is to support, empower, and counsel victims of sexual assault and other serious crimes in Bucks County, and to work toward prevention and elimination of violence in society through advocacy, training, community education, and prevention programs. Our services are free and confidential. The news over the past year has clearly revealed that workplace sexual harassment is pervasive in every industry, from the restaurant and other industries to professional football and news outlets. I am here today to share with you the deep and wide-ranging impact that sexual harassment in the workplace has on victims of such an act of violence. In my work at NOVA, I have the privilege to meet clients who rise to meet the overwhelming circumstances of their victimizations with extraordinary strength and resilience. One such client is Rachel, of course not her real name to protect the client's privacy, a woman in her mid-20s, joyful, energetic, with a passion for rock climbing and her job with a large Pennsylvania company. Rachel lives with her disabled mother, for whose care she is solely responsible. She was hired shortly after college and was working under the tutelage of a man, of a foreman, a man she thought had the warmth and comfort of a father figure. He introduced her to the rest of the team, and a short time after, they all had become friendly and enjoyed time outside of work. Rachel shared the shock, humiliation, and shame that washed over her when one day, while working on a ladder at a job site, she felt the hands of the trusted foreman groping her buttocks and genital area, grunting and describing the sexual acts that he would do to her. She froze. She couldn't move, she couldn't speak, she couldn't breathe. Her brain could not process that the fatherly figure whom she trusted was the same as her present assailant. In clinical terms, this is a classic trauma reaction, the fight, flight, or freeze response, a normal brain reaction to a perceived threat. When she came to, she told him he is making her uncomfortable and asked him to stop. The harasser did not. Paired up with him for jobs that were scheduled by the company well in advance, Rachel found herself bound to working with her harasser over and over again and facing in fear the unwanted advances and assaults each time. Because of the deep trust they had built over time, Rachel did not want to report the harasser to Human Resources for fear he would be fired. When she finally mustered the courage to share the story of the harassment with another coworker, one of the friends she trusted, he minimized the harasser's actions and laughed at her, telling her she needs to expect this in this field, and that he'd had those thoughts about her also. Utterly betrayed, without lateral support, and withstanding ongoing harassment, Rachel decided to escalate the issue to the team supervisor. The supervisor told her she would be removed from the projects to which she had been assigned and bound to what he called a desk job, a demotion from her current position. This demotion would affect her financial resources for herself and her mother, and she refused to accept this offer. She was told to grow thicker skin. Rachel decided to take things into her own hands and confronted the harasser. She was direct, assertive, and clear about the boundaries she wanted him to respect. He did not comply. 12 more times, Rachel reported the harassment to her supervisor. He dismissed each complaint and did not record any of them. By the time Rachel attended the first counseling session at Nova, she felt betrayed by her friends, let down by the system in which she believed and believed would help her, invalidated in her efforts to disclose, and overall less than human. She blamed herself for the harassment, despite knowing she had no control over the harasser's behavior. She was cut off from her social circle, the people who now supported the harasser. Isolated and disheartened, Rachel started to slip into depression, used alcohol to numb out feelings of anger and pain. 12 dismissed reports and countless incidents of humiliation and harassment had rendered Rachel in a state of learned helplessness. And her colleagues, her friends, and supervisor would not believe her, then no one would. This is the deep belief that most victims of workplace harassment, sexual harassment hold. This is why Rachel determined that our referral to the Human Resources Department or a direct complaint with the EEOC was no longer an option for her. In counseling, we validated her feelings, affirmed her actions against the harasser, and explored coping skills to heal from the sustained trauma of the harassment. A year after completion of services at Nova, I received a voicemail from Rachel. She was happy, working in a satisfying job, had found a new place to live and a new life in North Carolina. She had struggled with making this decision for a long time, struggled to make arrangements for her mother's care, struggled to gather financial resources to move, and struggled to quit a job she otherwise loved and leave the friends she had made. All this to escape the web of humiliation and trauma triggers that existed everywhere. Though not public or glamorized like those of Hollywood stars, the experiences of Nova clients who have withstood workplace harassment are equally ubiquitous and continue to replicate day in and day out. They are indicative of classic trauma symptomology and hence warrant the same degree of focused attention to seek a viable and workable solution. Workplace sexual harassment is traumatic. It adversely affects victims emotionally, behaviorally, and it infiltrates all aspects of their family and social lives. Sexual harassment involves a dynamic of power and control maneuvered by the harasser to the deep detriment of the victim. Sexual harassment is unsafe and toxic to the workplace, just as any bullying or harassing activity in the community. Sexual harassment is an issue that transcends gender, race, sexual orientation. It affects us all. Sexual harassment is not a knowledge or comprehension problem. It is an attitudinal and behavioral problem. Sexual harassment happened to Rachel, and it can and does happen to many of our own daughters, sisters, coworkers, or staff members. It is my strong belief that instituting legislation and public policies that address sexual harassment and enforce consequences that are significant and commensurate with its traumatic impact is the ethical and moral step to take to benefit us all. Thank you very much for having me here today.
Good morning. I want to express my appreciation for being included in this hearing today and thank Chairs Kauffman and Galloway for convening this hearing today and the members present as well. My name is Terry Fromson. I'm Managing Attorney of the Women's Law Project. As requested, I will summarize the key points and the highlights of my longer written testimony. We are in the midst of an extraordinary culture shift. The Me Too movement has unleashed an incredible number of disclosures and conversations about sexual harassment. Sexual harassment encompasses a broad range of behaviors, which at their worst include felonious sexual assault, but also include offensive and humiliating words and gestures which can create a hostile environment and have no place in a respectful environment. The disclosures have produced a range of reactions, from horror and empathy to denial and dismissal. I don't know how each of you has reacted. You may believe those reporting harassment are seeking revenge and lying. You may be concerned that those who are accused are being treated badly. I ask you to hear me out on why you should neither deny or dismiss that sexual harassment persists, nor dismiss the experiences that the women are sharing. And please know that the Women's Law Project believes both the complainant and an accused should have a fair process. Even though sexual harassment did not have a legal definition until 1979, it has been with us for a very long time and derives from centuries-old bias against women going back to the times when women had no legal status or rights and were considered the property of men. We at the Women's Law Project have observed this bias against and disbelief of women in the work we began almost 2 years ago in Philadelphia when we responded to the reports of police failing to investigate sex crimes because they did not believe the women reporting the crimes. This same bias occurs in our workplaces and other institutions. It is explicit, it is implicit, and it persists. Why would women lie about being sexually harassed? While celebrities are just now being congratulated for reporting harassment, most victims are not famous and have a lot to endure if they report and seek a legal remedy. Not only do they have to continue to go to work with the harassers and suffer ongoing harassment, once they are reporting, they are treated as outcasts on the job. Meanwhile, their complaints to management frequently do not stop the harassment, in which case they may be forced to leave and suffer economically. Bringing a lawsuit under anti-discrimination laws takes years, costs money, and provokes retaliation and loss of employment. There simply is no incentive to lie, and there should be no presumption that they are lying. The opportunity for real change is upon us. In addressing sexual harassment, however, I want to emphasize that legislative reform in this area should not be limited solely to sexual harassment. Harassment based on race, ethnicity, and other protected categories is equally malicious. One form of harassment should not be treated differently than other forms. It is also important to make reform victim-centered. Complainants should be able to choose on their own how to proceed and among the options that are available to them. We do not want to deprive a complainant of either autonomy or a remedy. We recommend a number of legal reforms that we believe can be adopted immediately to strengthen Pennsylvania's laws so that they provide remedies and protection for anyone who suffers sexual harassment on the job. We would like to see a mandate for employer policies and procedures for individuals with complaints of sexual harassment, as well as training of employees and employers about their rights and obligations. Individuals need to know that sexual harassment will not be tolerated and will be addressed. This includes the Pennsylvania General Assembly. House Bill 1965 can achieve this goal for the General Assembly. We would like to see expansion of access to the remedies provided by the Pennsylvania Human Relations Act. Lower the employer threshold from 4 employees to 1 employee so anyone can access remedies. Expand who is protected to include independent contractors, unpaid interns, and volunteers. Remove exclusions for agricultural and domestic workers, which are rooted in explicit racial discrimination. Expand the time for filing complaints to afford individuals more time to consider their options. Provide more staff and resources to the Human Relations Commission so it can promptly and timely respond to complaints. Provide for jury trials and punitive damages. We do urge caution with respect to 2 areas of reform that have been discussed in the public recently. The first relates to banning non-disclosure agreements. We do not disagree with the objective of such proposals to prevent the concealing of serial predators that allows them to continue to harass. However, there are complainants who want privacy, not publicity. There are those who cannot afford to pursue legal proceedings and who want a prompt resolution so they can move on. They might want to leave the harassing environment, obtain financial resources for the resulting gap in their employment, or need financial resources to deal with a therapeutic intervention they need as a consequence of the harassment on the job. Settlements allow for this, and leveraging an employer's interest in confidentiality can help a complainant achieve a quick resolution. A total ban may have the opposite effect. Therefore, we believe the person seeking relief from harassment should be able to make the decision about whether and the extent to which they would like to agree to non-disclosure. Another disclosure issue exists, however. Some employers impose broad non-disclosure agreements on their employees at the time of hire. These should be categorically banned. They will prevent an employee from even filing a complaint of harassment with a public agency. We also support transparency in a way that will require employers to publicly report, the number of complaints, the types of complaints, and the outcomes of complaints. The other area in which we advise caution is prohibiting paying settlements out of public dollars. We do not agree that Commonwealth agencies should be prohibited from paying settlements for sexual harassment or any other type of work-related discrimination. Commonwealth agencies are employers, like any other employer, who have long been held responsible for preventing and remedying discrimination in the workplace. To remove a remedy for sexual harassment, only one aspect of one type of discrimination, undermines the entire civil rights structure about sexual harassment. Elected officials are somewhat different, as they are only fully accountable to voters. We, of course, appreciate the concern about public dollars being used to settle a sexual harassment claim. However, taking the public purse away as a source of recovery might leave a victim without the option of settlement. It could deter the harasser from settling, and depending on the resources of the harasser, remove the source of damages. Finally, fair process, again, is essential for all parties. Thank you for this opportunity to address you today.
Thank you very much for your testimony today. I want to recognize those members who arrived since the call of the roll, and those are Representative Delosier, Representative Klunk, Representative Keller, and Chairman Galloway. Our Democrat chairman has come since the roll call, and I just want to recognize him for just some brief remarks.
Thank you, Mr. Chairman, and I want to thank all of you for being here today and all the testifiers for taking time out of your day. And I want to thank the Chairman Kauffman for not only bringing these bills into this committee, but holding a hearing and putting a spotlight on this issue. We appreciate it. This is very important. Real quick, I'm struck by, I was speaking to my wife last night, and I was telling her about this hearing. First of all, good to see my friend from Bucks County, by the way. Thank you for being here. I was speaking to my wife, and I was telling her how uncomfortable I was about talking about this subject. And you know, as a man, I guess it's, you know, it can be difficult to acknowledge or discuss or feel like I'm an equal. You know, I'm sitting in front of a panel of women. She said, John, you don't understand it. She said, you know, as a woman, harassment is something we live with every single day. It's as common as breathing. I'll never forget she said that. She said it's as common as breathing. And, you know, I just want to say as a man, not even as a legislator, I know we're here to find answers, but, you know, I got a lot to learn. You know, we got a lot to learn. And thank you for being here. Appreciate it.
Thank you. And we are going to move on to question and answers. And again, I want to remind members to keep their questions succinct so that we can get to the list of members who have questions to ask. Representative Topper will begin the questions and answers.
Thank you so much. Thank you, ladies, for your testimony. I guess possibly, Ms. Fromson, if we could talk a little bit about what you just said about non-disclosure agreements. So this has been an issue that has really caused me problems from the beginning. You know, when I first thought about banning non-disclosures, I thought that's great. Like, I want to do that. That makes sense. These things need to be exposed. I thought about the banning of public dollars. I immediately was on board with that. Those are just kind of your instincts that kick in. And then the more I thought about it, and then hearing you this morning kind of reinforced that perhaps we were also not looking at it from a victim side. You know, we tend to see the Hollywood celebrities come out, especially with the Me Too movement, and they want the publicity, which has been a good thing in some ways. But many people back in my district probably would not want that. They would choose to do things quietly. They want justice, they want it settled, but they rather not have everybody's names out there. And so I guess I'm struggling for that balance. You mentioned that individuals seeking relief from harassment should be able to make that decision. But from a public policy perspective, are we really able to craft a law that would allow kind of whatever anybody wanted to do based on a given circumstance? What as someone within the law, how do you feel about that?
So let me just say I understand your initial instinct and the initial instinct of others around the country wanting to completely ban non-disclosures. It's kind of an automatic response to preventing further harassment, but we're not willing to sacrifice a victim who needs and wants confidentiality based on such a ban. I think it is possible to write into the law a provision that allows complainants to make the choice. Senate Bill 999 was introduced in the Senate, and work has been done on it to amend it. As amended, it does make this provision. So I think it's perfectly possible to provide that autonomy for someone who needs it.
Is there anything in that, and I haven't seen that amendment to the Senate bill, that would preclude a victim from saying, well, you know, maybe 5 years later they hear that the perpetrator's at it again and they regret that decision for a non-disclosure, they want to change their mind. Would anything preclude them from coming out and saying, look, this happened to me as well, or is once the non-disclosure done, it's a done deal? I'm not I'm one of the few in the room who's not a lawyer, so
Right.
I count on the lawyers to provide me with that kind of expertise.
I understand. So, on the one hand, the revised Senate Bill 999 does not say you have to agree to all of it or none of it. I can imagine that there are individuals who make a choice of what they would like to have remain confidential and what options they might like to pursue. So, for example, if someone wanted to hold on to the ability to testify, for example, in the future, either in a public venue like this one or in a lawsuit, that could be reserved. To the extent that an agreement is executed, I will say I'm not an expert completely on all of this, but certainly if a non-disclosure agreement is found to be in violation of public policy, there might be a possibility for someone to be able to speak up later. It's interesting, the non-disclosure agreements often occur in private settlements, even in cases which have a claim but have not been filed in court yet. To the extent that a lawsuit is under the supervision of a court, those kinds of agreements might not pass muster for a court. They have an obligation to weigh the value of the public interest in a lawsuit against the private interest. So there are those options as well that are available.
Thank you. Thank you, Mr. Chairman.
Thank you. Moving on to Representative Kruger-Branicki.
Thank you, Mr. Chairman, and thank you to all three of you for testifying today. I'm very glad that we started with the victim and survivor perspective first, because I think that's how we need to frame this issue anytime we look at it here in the legislature. So I have read that industries with stark power differences have different rates of sexual harassment. Can any of you speak to that? Have you found that to be true? Is there data that supports that?
Yes, thank you. One of the reports that I consulted largely in preparing remarks today is from the Equal Employment Opportunity Commission Select Task Force on Sexual Harassment and Misconduct, which was released in 2016. So I would point you to that resource for further reading and sharing, but they do identify elements of workplaces that increase risks for sexual harassment. So I know, as fellow panelists said, that sexual harassment knows no specific industry, political party, or geographic location. It really spans every workplace, but there are elements that are higher risk, such as a lack of diversity in the workforce, so highly male-dominated workforces with just a minority of women, for example, or if there is a lack of racial diversity in a workplace, that can increase the risks for sexual harassment, as well as those power imbalances. So stark differences of a very structured hierarchical structure can also increase risks. Isolated environments, if alcohol is encouraged, both in the workplace and outside of the workplace. A young workforce, so as you have new employees entering into the workforce, that can also increase risks for harassment. People with disabilities are at higher risk as well, and certainly women. So I would point you to that resource and be glad to share it with the committee for further discussion as well.
Wonderful. And as someone who's been attempting to address the issue of sexual harassment here in this Capitol, it appears that we're in an increased risk environment given those factors. Thank you.
Thank you. Moving on to Representative DeLozier.
Thank you, Mr. Chairman. Thank you all for being here and your insights on the different issues that we have in front of us. And I just want to go into a little bit of the avenue as to how many different subjects that we have out there when we deal with sexual harassment. And when I say that, I mean that you've talked about many studies, you've talked about many pieces of information that you've gathered, talked about victims themselves. So there's so many moving parts when it comes to this, and so many different types of victims. So one clarification I just wanted to say is that we have men and women that are victims of sexual harassment, correct?
Yes.
Okay.
That is correct.
And could you speak to possibly some, Nova, I'm sure in that regard, having both men and women come for services within your?
I couldn't thank you enough for that question. As I said in my remarks, it knows no boundaries with respect to gender. To give you just a snippet of the work that I do know, we receive about 3,500 clients a year. So that's kind of the population that we serve. Out of that, about 45% are related to sexual assaults, harassment included. Out of that, about 30% are male. So to just give you a snippet again of the work that
30
we
of
do,
the 40?
30% of the 45.
Of the 45,
Of
okay.
the 45, correct.
Okay.
Per year.
Okay, thank you. And I just wanted to clarify that simply because there is a general assumption, and obviously the majority certainly are women that endure, but there's a little bit even more of a stigma, I believe, for a man to come forward to admit that this is happening and everything else. It doesn't minimize either side. It's just a matter of that it does go across the parameter. I wanted to also, Donna, you had talked a lot about the studies and the 85% that don't report and the 70% that never make that report with their employer. One of the questions that are come up again and again is the fact that because they don't report, how do we have these statistics? So we have the statistics of those that come forward because we talk to them and we counsel them. And granted, a lot of the folks that you counsel, I know, may not have made that report, but they still seek counseling, which is good, and we want to encourage that. Can you kind of, for the committee and for the record, just talk about the fact of where do we gather a lot of these statistics? How do we get the numbers to understand how prevalent this is without the actual reports that people make or those that come forward?
Sure, thank you for that question. So while so many victims don't come forward through those formal channels, whether reporting to law enforcement or their workplaces, the studies that are available to us do find that there's a higher prevalence than what is actually reported. So that's where some of the discrepancies will emerge.
How do you get to those people, I guess, is the kind of, how do you know, since they haven't made this report, you don't know to go to Ms. Smith over here to talk to her about her experiences and why she did what she did and maybe where the gaps were that she would have preferred to have a more secure reporting process or whatever her issues may have been. How do we understand the dynamic of those that don't report and how do we talk to them?
Yeah, those are great questions. And I think some of the studies that I would be happy to share, they did longitudinal research. So they followed individuals from sort of those teen years, because we know that the first experience of sexual harassment is actually in those teen years, in those early teen years. And then people go on to experience multiple victimizations. So there are studies that sort of follow people into the workforce and over time in the workforce. Again, those are studies that are designed so that victims feel comfortable coming forward. They don't have to go through a criminal justice process. They feel comfortable talking with the researcher and really responding to questions that ask them not just have you been sexually harassed, but have these specific actions and behaviors. And we find that the more specific those questions are when you're talking with someone, the better data you're going to get and the more accurate data you're going to get. Because a lot of people don't label what happened to them as sexual harassment. But did somebody touch you inappropriately? Did somebody keep asking you out? Did someone make anti-female or anti-male comments directed at you? So the more specific you can get, the better. There's another study that actually was just released in February of this year that did an online survey across the country. It's a nationally representative sample of women and men. 1,000 women and 1,000 men were interviewed online. Again, they did not have to attach their names to it. So sometimes when you take that stigma off and you take the lack of control over your information off, you'll get more honest responses from people. So thank you for that question.
No, sure, and I guess that kind of leads into one of my last ones, is the issue of the definition of sexual harassment. You mentioned that the legal definition in 1979, I didn't know the year, so that I learned that, but there's lots of different versions, and we have our federal law, we have our state law, we have, and each company, a private entity or public entity, obviously will define, they have to abide by the law, certainly, but they do a policy. They do their own version of what it is and what their process is. Can you speak to any gaps or anything to allow for us to have a good, solid basis, or what, in your opinion, would allow us to have that solid basis of having one definition and one kind of across the board? And that's what we're also looking at here within the House and the legislature as a whole. We have 3 different sexual harassment policies, with the Senate having one, the House, ours and the House D's having one. Why do we have 3? So I guess it kind of goes to not only the law itself, is there a gap in the actual legislation of what the definition of sexual harassment is, or is it policy driven in the sense that we need to make sure that we are all on the same page internally, whether it be a public entity or a private entity, to understand what is, because I think we have to strike that balance. The description you gave of her, the client that you mentioned, obviously shouldn't have happened, and what she went through and the 12 reports that she made and everything else should have been listened to, absolutely. But we end up going so far, the pendulum, it happens with every issue that we have, we need to find that balance, and we can't swing so far that someone touching your shoulder is, well, you can't touch me, you can't do, we need to find that balance. And so that's why I'm asking kind of, where do you see gaps in what we have? Is it legislation? Is it law that needs to change, or is it policy that needs to change? So what is your kind of feedback on that?
So there is a legal definition of what is unlawful sexual harassment.
Is that you said the 1979 law? Is that the one you're referring to, or?
The 1979 reference is to the fact that we gave it a name,
Okay.
sexual harassment, and then it became defined in the law, in federal law, and Pennsylvania state law pretty much follows Title VII's definition. That is the definition that will hold an employer liable for violation. I think there is a broader definition that could be constructed for what is inappropriate in the workplace, and that I would encourage employers to adopt, so that in their role as the entity that is to prevent sexual harassment in the workplace, they can stop it when it first appears. So while the law may impose liability for what is the quid pro quo sexual harassment, or the repetitive or severe harassment that will create a hostile environment, I think there are everyday offensive comments, gestures, touches that may not reach that threshold, or may not reach a violation in a court of law, that our employers should address. Because what we want to do is not avoid liability so much as eliminate sexual harassment in the workplace.
So basically, so again, we have to kind of have that balance of the legal ability to find liability if necessary, criminal if necessary, but on the other side then have policy. Okay, the chairman's giving me a dirty look. I'll end that with that. Thank you very much.
Thank you. It was a great discourse. So I hated to cut it off, but we need to move on. Representative Menser is the next question.
Thank you, Chairman Kauffman. I'd like to go back to this non-disclosure clause and non-disclosure agreements. Ms. Fromson, you've been very specific about your feelings on the issue. I'm wondering if Ms. Greco and Ms. Nachita would be willing to suggest whether they agree totally with those observations, or whether you have your own observations.
Thank you. Yes, PCAR also would echo what the Women's Law Project shared about banning the required non-disclosure agreements, but also enabling victims and survivors to invoke that in their workplaces should they choose after informed consent and they're considering their options. We were concerned that banning all of them, while we appreciated the intent, it's really to break the silence and to hold people accountable for multiple assaults, and we applaud that. And that speaks to the prevention side of the mission of our coalition, to really break the silence around rape and sexual violence. But then on the other hand, it would do a disservice to individual victims who would also feel restricted by not having that option any longer. So we did work closely with the Women's Law Project as well as the sponsor in the Senate on that bill, and to really think through how to make that available to victims to invoke after they've given it much thought and after they've consulted with various options. So we would echo the comments of the Women's Law Project on non-disclosures.
Thank you very much. And again, I couldn't agree more. And of course, we do support such a ban. And to give you, because I'm a mental health professional, I am not a lawyer, I'm not a policymaker, I'm a mental health professional. So to give you just a snippet of the emotional context of the victims of sexual harassment, especially if it is sustained in the workplace, there is simply no clarity of feeling or of thought during the process of just clarifying options for themselves at this point. So not only do we need to support them emotionally, but to kind of, again, to clarify those options, to have those options available to them at a later point should they choose to do so, is critical for victims of sexual harassment to have as a tool. So thank you.
Thank you.
Thank you very much. Moving on to Representative Dush.
Thank you, Chairman, and thank you for your testimony. Awana, you did a great job with when you described workplace sexual harassment as traumatic, and it adversely affects victims emotionally and behaviorally. And the important part, it infiltrates all aspects of their family and social life. There's no escaping it. It goes on and on, especially when it's ongoing within the workplace. What's the greatest barrier for victims that you see when it comes to them coming forward and reporting?
What a wonderful question. Thank you for paying attention to that issue. Non-disclosure, to begin with, not used in a legal term, by the way, is a huge issue. As Donna had mentioned before, a lot of the victims with whom we work, especially in our counseling sessions, do not actually make an official report. Some of the barriers that we have found and research supports is not being believed. So there are two dynamics as far as research has shown and what our work has shown as well. Victims come to this strong belief that nobody will support them and nobody will believe them in their disclosure. At the same time, when sexual harassment in the workplace might be an ascendant type of a dynamic. So it might begin with a touch on the shoulder. It might begin with an inappropriate comment, and then it escalates from there on out. By the time it comes to a point where it becomes so egregious that a disclosure would be warranted by all intents and purposes in anybody's view, the victim is already well under that oppression of shame, embarrassment, confusion, and the lack of lateral support, whether it's colleagues or the system within the workplace that does not support the victim to make a disclosure, is one of the other barriers. So not being believed, not being supported by colleagues, not having a point of report that is of multiple points of contact, right? So if I only have one person to whom to report sexual harassment, I may or may not have collegial or otherwise relationship with that person. If I know I have 5 other different people to whom I could report the sexual harassment, it might make it more likely for me as a victim to come forward. So having multiple points of report, I think that would help as well. And that's a barrier at this point in time. I could go on and on about the emotional context of that, the shame, embarrassment. A lot of victims internalize the harassment, thinking, I must have done something to provoke this. So we work, of course, right, irrational thinking, which, of course, we detangle in counseling, but that is one of the biggest barriers as well. A culture that supports that kind of toxic thinking is also detrimental to reporting sexual harassment. And again, women, I know women because I am one, men, of course, as well. We live in a culture that supports certain gender, traditional type of stereotypes, and I think that's toxic as well to reporting. Thank you.
Thank you. I know the chairman, I have some other questions, but I know the chairman needs to keep this going.
Thank you. I truly appreciate you ladies being here today, and especially your work with victims in Pennsylvania. We do need to move on to our next panel, but we will continue to use you as a resource as we move forward in the discussions on this issue. So thank you very much.
Thank you.
Our next panel this morning will provide us a legal perspective. We have an attorney who represents employers in workplace harassment and sexual misconduct cases, an attorney who represents plaintiffs, and we have an attorney who works with employers to help them implement their workplace policies and procedures. So joining us this morning, we have Eric Meyer, partner with Fisher Broyles, Larry Weisberg, partner with McCarthy, Weisberg and Cummings, and Teresa Mangiovi, partner at Brubaker, Connaughton, Goss, and Lucarelli.
Perfect.
Okay, well, I doubt it was perfect, but thank you very much. So I'm going to move forward with this panel. Would encourage you to summarize your statement as much as you can within 5 minutes so we can move on to questions from the panels, or from the group of legislators here. So thank you very much, and you may move forward as I called you or however you see fit.
Good morning, Chairman Kauffman, Chairman Galloway, members of the House Labor and Industry Committee. Thank you for offering me the opportunity to testify today. My name is Eric Meyer. I'm a partner with Fisher Broyles, LLP, which is the largest cloud-based law firm in the world. I'm a labor and employment attorney, generally representing management. I also publish a labor and employment law blog called The Employer Handbook and serve as a volunteer mediator with the U.S. Equal Employment Opportunity Commission. Additionally, I am a frequent lecturer across the country on all things employment law, including sexual harassment. Someone recently commented to me that I live and breathe employment law. I did not correct him. I am honored to be here today to discuss current state and federal laws governing workplace harassment and sexual misconduct, related legal issues, and employer best practices. Title VII of the Civil Rights Act of 1964 is the federal anti-harassment law. Title VII prohibits employment discrimination based on race, color, religion, national origin, and sex. Title VII was the culmination of the growing civil rights movement in the 1960s. However, Title VII almost never came to fruition. Howard Smith, Virginia, the Democratic chairman of the Rules Committee, added sex as a last-minute amendment to Title VII during Senate debate. Mr. Smith planned his one-word amendment as a poison pill for Title VII. However, his plan backfired. The Senate passed the bill, and President Lyndon Johnson signed Title VII into law. Still, Title VII's passage was met with a mix of toxic fear and crude humor. The New York Times editorial board worried about whether the Rockettes would have to allow male dancers. And when a reporter asked Franklin D. Roosevelt, Jr., the chairman of the EEOC, "What about sex?" He replied, "Don't get me started. I'm all for it." Since then, we know Title VII to be one of the most important laws for the advancement of employee rights in the workplace. In 1969, Title VII was amended to cover pregnancy discrimination as a subset of sex. In the years that followed, the Supreme Court has stamped its imprimatur on Title VII. The highest court in the land has outlawed sexual harassment, ruled that sex stereotyping is a form of sex discrimination, and in an opinion authored by the late Justice Antonin Scalia, unanimously recognized that same-sex harassment violates Title VII. For its part, after an inauspicious start, the EEOC has transformed itself into a Title VII trailblazer for American workers. In 2012, the EEOC concluded that transgender discrimination violates Title VII as a form of sex discrimination. In 2015, the EEOC determined that discrimination based on sexual orientation violates Title VII too. The following year, in 2016, the EEOC Select Task Force on the Study of Harassment in the Workplace was formed. Its mission was to address the consistent problem of workplace harassment and to propose solutions to the problem. Consider that the EEOC receives tens of thousands of charges of workplace discrimination each year, while many other victims of workplace harassment suffer in silence. Although the vast majority of HR professionals report that their company has a sexual harassment policy, almost 1 out of 4 non-management employees don't know whether this policy exists. Worse yet, roughly 3 out of 4 individuals who experienced harassment did not complain to their employer. That brings us to 2018. There hasn't been a spike in sexual harassment claims filed with the EEOC. However, headline-grabbing stories of business leaders behaving badly have helped to galvanize the Me Too movement. And businesses are taking to heart recommendations of the EEOC Select Task Force for best practices that employers should implement to improve how they address workplace discrimination. The task force identified leadership and accountability as 2 starting points. This holistic approach is top-down and requires buy-in at all levels. Companies must create systems to foster an organizational culture in which harassment is not tolerated and in which respect and civility are promoted. Zero tolerance is the buzzword. But zero tolerance does not mean that every infraction of an anti-harassment policy results in a termination of employment. However, zero tolerance means no more free passes, especially for the business leaders. Additionally, companies must create an environment in which employees not only understand anti-harassment policy and procedure, but are encouraged, not chilled, from complaining about workplace behavior that may violate the policy. Consequently, while retaliation remains the #1 claim of employment discrimination filed with the EEOC, companies must reinforce the message that they will not tolerate reprisals against those who complain about harassment at work. Thank you again, Chairman Kauffman, Chairman Galloway, and the members of the House Labor and Industry Committee for offering me the opportunity to testify today. And when the panel finishes, I am happy to answer any questions that you may have. Thank you.
Good morning, Chairman Kauffman, Chairman Galloway, and distinguished members of the House Labor and Industry Committee. Thank you for inviting me to participate in your panel discussions this morning. My name is Larry Weisberg, and I am an attorney and one of the founders of McCarthy Weisberg Cummings PC, a law firm based here in Harrisburg. For the past 11 years, my practice has focused primarily on representing employees who feel their rights have been discriminated against by their employers. I practice in both state and federal courts here in Pennsylvania, and my practice regularly involves filing cases with both the Pennsylvania Human Relations Commission and the Equal Employment Opportunity Commission. I also serve, as does Mr. Meyer, as a pro bono mediator for the EEOC. I'm currently an officer for the Pennsylvania Bar Association's Labor and Employment Section Council, and I am an adjunct professor at Widener University Commonwealth Law School, teaching employment discrimination law. As a practicing attorney who routinely represents employees, I believe there are reasonable protections in place for many employees in the Commonwealth who believe they are victims of workplace discrimination and/or harassment with respect to sex, as well as other legally protected categories. However, there are several areas under the law which I believe have room for improvement, and I will discuss those briefly in my prepared testimony and will also be happy to address any questions from the committee members. Most employees in the Commonwealth have recourse under the Pennsylvania Human Relations Act if they believe they have been discriminated against or harassed on the basis of the protected classes which Mr. Meyer spoke of. Sex discrimination includes sexual harassment and pregnancy discrimination, as well as discrimination based solely on gender. Employees are also protected from retaliation by their employer if they file a claim or make an internal complaint of discrimination based upon one of these classes. In addition to the state law, there are protections, as Mr. Meyer spoke of, under a combination of Title VII, the Americans with Disabilities Act, and the Age Discrimination in Employment Act. As I mentioned, there are several areas where I believe the law falls short, and I was happy to see in flipping through the packet of materials I provided that some of them are addressed in some of the bills that are currently being considered. First, the PHRA applies only to employers with 4 or more employees in the Commonwealth, and Title VII applies only to employers with 15 or more employees. Therefore, employees who work for employers with fewer than 4 employees in the Commonwealth have no protection at all from workplace discrimination and harassment. When we are contacted in our office by these types of employees who work for smaller employers, we simply have to tell them that there is no recourse available under the law. I was happy to see that House Bill 2280 seems to address that issue by lowering that number from 4 to 1. Second, even for employees in the Commonwealth who are protected by the PHRA and Title VII, the damages which can be recovered, even in the most egregious of cases, is limited by statute. Under both the Title VII and the PHRA, an employee can recover for direct economic loss as a result of their claims. However, under the PHRA, one employee can recover for their own non-economic loss due to humiliation and embarrassment. Punitive damages are not available to punish an employer whose behavior is found to be either malicious or reckless. I do note that House Bill 2286 seems to add language to allow for punitive damages. Even more limiting when an employee is pursuing a case through the PHRC, which is required for a year right now before a claim can be pursued in court, no damages are available other than actual economic loss, which may not even exist in some cases where an employee continues to work for the same employer or moved on to a new employer without economic loss or a decrease in wages. Although Title VII allows for both non-economic and punitive damages, there are caps in place which can severely limit recovery. As such, the laws in place often fail to provide sufficient deterrent to employers. Employee rights are also limited to some extent by the administrative process in place under the PHRA. Before an employee can file in court, the matter must be filed in the PHRC and must remain there typically for a full year, during which time a resolution is unlikely. Title VII, on the other hand, requires claims to be filed with the EEOC for only 180 days, so when an employee wishes to pull their claim out of the EEOC and proceed in federal court, they still must wait another 6 months to file their state claims under the PHRA. PHRA also fails to provide an employee a right to a jury trial should the matter proceed into the court system. And I note that House Bill 2286 also seems to address that issue and provide a right to a jury trial, as well as expanding the time for reporting in the first place to the PHRC from 180 days to 2 years. And I would note that that statute of limitations for employees in these types of cases is shorter than the statutes in almost any other type of claim out there. Even for federal law, you only have 300 days to report. Under state law, currently you have 180 days. Finally, the PHRA and Title VII also fail to explicitly cover certain protected classes which are covered under the laws of other states, such as sexual orientation and marital, civil union, or domestic partner statuses. With respect to pending litigation, the Pennsylvania Bar Association Labor and Employment Council was recently asked to provide comment regarding the proposals to limit the ability of an employer and employee to settle sexual harassment cases with respect to the non-disclosure issues which have been discussed already this morning. Opposition to this concept is one area where both the plaintiff and defense bar agree. In fact, any hindrance allowing parties, particularly those represented by counsel, to enter into a mutually acceptable, amicable resolution of disputed matters should be thoroughly vetted to avoid unintended consequences. Most clients who end up in my office because they've been harassed in the workplace are not looking for publicity, and they certainly are not looking to get rich. They are typically a combination of afraid, anxious, and embarrassed, and just want to move on with their lives. They're often trapped in jobs with harassing bosses or have been terminated because they dared to stand up to their harasser. Either way, they look to attorneys like me to help them escape their situation and move on with their lives. As I explain to my clients, there is a difference between the legal world and the real world. Although they may have legal recourse in the court systems, that process is lengthy, it is nasty, and it is anything but certain. In the meantime, the real world moves on, and they typically have bills to pay and families to feed. That's where rational discussions between employers and employees, even over highly disputed claims, can lead to an efficient resolution that allows the aggrieved party to move on with their life with dignity, bridge the gap to the next opportunity, and avoid the cost, uncertainty, and time associated with litigation. Because these claims are often highly disputed, the employers will typically not settle them without assurances of confidentiality and without an explicit agreement that there was no admission of guilt or liability. Even as a plaintiff's attorney, I cannot say that I blame them. These clauses are included in release of all claims that an employee may have against an employer. Unfortunately, limiting the ability of an employer to enter into a confidentiality agreement will greatly squelch the opportunity for employees to resolve their case and move on with their lives. Ultimately, I fear this will dissuade employees from coming forward at all and will make the problem worse, not better. Of course, in cases involving criminal behavior such as sexual assault, the victim can always report such activity to law enforcement, and I encourage my clients to do so. And of course, no one is required to settle their case if they do wish to tell their story. I would also note that in the discovery process of litigation, there is often an opportunity to find out from the employer what other complaints have been made and explore comparators. And in fact, in most cases, non-disclosure agreements can be modified under order of court. So if someone has a non-disclosure agreement and a court orders them to talk about it, even the non-disclosure agreements will recognize that that is an exception. In summary, I believe that even well-intentioned legislation which interferes with parties' ability to amicably resolve a claim misses the mark with respect to solving the problem of workplace harassment. Thank you again for inviting me, and I would be happy to address any questions of the committee members.
Chairman Kauffman, Chairman Galloway, and members of the House Labor and Industry Committee, good morning, and thank you for the opportunity to testify today regarding best practices to prevent harassment, discrimination, and retaliation in the workplace. My name is Teresa Monjovi. I'm a partner at the law firm of Brubaker, Connaughton, Goss, and Lucarelli, and I practice primarily in labor and employment law for the past 20 years. My emphasis is on management-sided relationships, although I also occasionally will represent executives in labor claims. I advise employer clients of all sizes on all aspects of the employment relationship. I work with clients to develop and implement proactive strategies so that they don't end up in a courtroom. I provide direct training to companies on all areas of labor and employment, particularly discrimination, and I also litigate these claims in federal and state court as well as in agencies. In addition to my day job, I also currently serve as the president of Lancaster SHRM, Society for Human Resource Management, which is an organization that focuses on providing educational opportunities to HR professionals. Harassment and discrimination are symptoms of a widespread problem of gender inequity in our workplace. Despite having laws on our books in this Commonwealth and in our nation for over 50 years, we're still seeing a significant number of overt and subtle workplace harassment and discrimination behaviors and claims. What more can and should employers do? I've provided you with approximately 14 pages of specific recommendations because I feel so strongly about this, which I will not go over in detail. But I would like to highlight for you some of the more important recommendations that I incorporate in advising my private companies each day. First and foremost, leadership must take the lead in this battle. It has to begin in the C-suite and in leadership of any company or organization. In the past, this type of issue was delegated to human resource professionals, and that's not good enough. Leadership must be engaged and visible, both formally and informally, in the workplace programs and initiatives that are developed. These are workplace culture problems. They're not human resource problems. Women and men must work together to be part of the conversations and solutions. Our perceptions and our frames are different culturally. Senior leadership must say and demonstrate that a workplace free of harassment and discrimination is not discretionary. It's not political correctness. It's an expectation in a workplace. Number two, we need to do better at developing easy-to-understand written policies. The foundation of any effective harassment prevention program is an effective policy. Robust, easy-to-understand written employment policies regarding discrimination, harassment, and discrimination are the essential for every workplace. The policies should define harassment in layman's terms. They should identify specific examples of overt and subtle forms of discrimination, and they should make clear that behavior from coworkers, supervisors, and third parties with whom employees may interact with all fall within the scope of a policy. Prohibitive activity should not only be in the physical site of the workplace, but all company-related activities, including fieldwork, travel, and company-sponsored events. Defined reporting procedures should be identified, including how an employee can complain and who they should complain to. Any person identified in a policy as a representative to whom a report can be given must have in-depth training on harassment and discrimination and how to take a report and counsel a person through a report. Leadership should obtain active feedback and test reporting procedures to assure they are effective instead of assuming they are effective. My third recommendation is that I believe a best practice is to enact anti-dating policies for supervisors in their direct or indirect reports. Workplaces should consider these policies. Dating relationships between supervisors and reportees can create an actual or perceived imbalance of power for those individuals and for those that work with them. Once a consensual relationship ends, boundaries are often blurred and behaviors that were previously welcomed become unwelcomed. Key issues. Another recommendation that was touched upon in Mr. Meyer's original address is that workplace training programs need to be modernized. One of the other conclusions or recommendations of the EEOC task force has been recommended is that despite all these years of doing training for our companies, we're not seeing a huge impact on those trainings. Why is that? One of the reasons is because they're not effective. It's not just important to do training. We can't just pop the VCR tape in the movie and have people watch it. We have to have the right kind of training. Ineffective training can often do more damage than no training in some circumstances. As more specifically described in my written testimony, the EEOC Select Task Force made a number of key recommendations on what is effective training that they're still working on. Some of the key elements that I believe should be considered are, again, one, company leadership must be visible and engaged in the training process. They need to be there. The employees need to see that they believe this is important and that it will be enforced. Two, ongoing customized training must be conducted for leadership, the C-suite, employees who accept workplace complaints, supervisors, and frontline employees. And the training is different for each level of the organization. Overt and subtle forms of discrimination, including unconscious and implicit bias training and bystander training, are key elements of a robust training program. 3, a training program needs to be customized to the work environment. Providing hypos about an office in a manufacturing setting is not effective or meaningful for those employees. Training must be conducted on a routine basis and reinforced on a regular basis throughout all elements of an organization, not just formal training. Another recommendation is that, although hard to say and understand, complaints must be welcomed, not discouraged. Leadership should understand that with the previously mentioned steps, workplace complaints may actually increase as people feel more comfortable bringing complaints to the attention of leadership. These complaints should be welcomed and not silenced, as it gives employers an opportunity to truly know what their workplace culture is and to correct it when necessary at the fundamental stage before it evolves into a lawsuit or escalates. And finally, I believe that we should encourage voluntary settlement agreements, including confidentiality clauses in settlement agreements. I represent a number of private employers, and I can't imagine one of them signing a settlement agreement without a confidentiality clause. It's not only based and weighted in favor of the employer, it's also based and weighted in favor of the employee. People should have the ability to make decisions about what should go in an agreement, and many victims do not want things being public knowledge. They want to be able to move on with their lives, just like the employer does. Thank you for the opportunity to provide some recommendations to you, and I look forward to any questions you may have.
Thank you very much. As we prepare for questions, I want to take note that Representative Cephas, Representative Kiefer, and Representative Grove have entered the committee meeting since the call of the roll. And first question, I'm going to call on Representative Menser.
Thank you, Chairman Kauffman. I think it's impressive that we're all here and we're all about protecting the complaints for legitimate victims. And that's a very serious issue here. I just have a question concerning false claims of workplace harassment. Is it a prevalent issue? Is it something that you have seen over the last several years? And could you describe, an example of that and how we can protect ourselves or protect those innocent victims of accusations?
Thank you for that question, Representative. Yes, I have seen false complaints. The integrity of the investigation process, which I know you're going to hear about this afternoon, is really the solution for that process. There is an ability internally for companies to investigate matters and make decisions on whether they believe there is merit or no merit in a complaint. One of the things that I focus on in training companies at all levels is that oftentimes there are cases where people overtly lie about things, and it does happen sometimes. Not an overwhelming amount in my experience, but it does happen. And there are cases that are gray, that everyone has a different lens and that there's a perspective that one person has that another person did not understand or hear. Those are often the areas that I spend time talking to people about, to understand that everyone has a different lens and that you shouldn't assume that your way of the world is everyone else's, and that while one person may be comfortable with a touch on the shoulder, another person may not be. So I don't know if that answers your question, but I believe, yes, there are false complaints, but there are often instances where there are perceptual differences where the answer is somewhere in the middle. And
so you believe that there are, in most cases, significant safeguards against false accusations?
I'm a lawyer and work in the legal system, and I believe that at the end of the day, the legal system does ferret that out.
Thank you very much.
Representative Kruger-Branicki.
Thank you, Mr. Chairman. I actually have a follow-up question to my colleague's question about legitimate victims. In the panel before you, Pennsylvania Coalition Against Rape testified that there's actually research shows a consistently low rate of false reporting. So I'm wondering if the three of you can speak to, we just heard, yes, you have seen false complaints. About how many? What percentage of the complaints that you see would you qualify as false?
I couldn't answer that statistically because I haven't tracked that as a practitioner, but I would say it would not be a majority of false complaints that I have seen.
Okay, gentlemen.
So when a client comes to me, they're looking generally to pursue a claim. I mean, we do our best to try to vet out whether we believe they are credible or not. One of the issues a lot of victims face is there's not often a lot of witnesses. I mean, most perpetrators are not doing this out in the open, so it's quite often one person against a whole host of other people. So it's difficult to say that somebody's claim is false. I can tell you in one or two instances, we've had people actually say, if they're not going to take this seriously, I'm going to say that the guy did this. And I mean, at that, that the guy sexually harassed me, for instance. And, as attorneys in that case, we're going to move away from that client. That type of explicit, I'm going to make something up, has only happened one or two times in our experience.
Out of how many cases that you've taken?
Hundreds.
Hundreds. So one or two times out of hundreds of
That
cases.
someone explicitly said, if they don't take my claim of this seriously, I'm going to make up and say that somebody did this or yes.
And Mr. Meyer?
Anecdotally, the number's very low.
It's very low.
I'd say I can think of maybe 3 off the top of my head.
Out of how many cases?
Hundreds.
Hundreds. Okay. So
where we were able to establish that the accusations were absolutely false, not looking through facts at a different prism, but absolutely false, and we fired each individual.
Okay. So overwhelmingly, these are a pretty small number of false claims in your experience.
Not only is there a very small number of false claims, but the script has changed in recent months, certainly. So whereas many HR professionals or folks who have conducted investigations, untrained professionals, might have looked at it and thought this is like a courtroom. The victim is innocent. The harasser, the alleged harasser, is innocent until proven guilty. I think it's the other way around. I think that people come forward with mostly verified complaints. Now, again, we may look at facts through a different prism, but someone who is complaining that they've been groped or touched, the vast majority of people are not making that up. So when we're conducting that investigation, when I advise clients to conduct that investigation, or when I'm conducting it, my initial look into it is, I believe this person. Now, I'm going to do a full investigation. I'm going to vet their story, but I believe that person going into it. That's how I approach investigations.
Thank you very much.
Thank you. Representative Delosier.
Thank you. I just had a real quick legal question. You referred to, and I appreciate the background on the Title VII and then our state laws. You mentioned that there is a cap for Title VII. What is that cap, that liability cap?
The caps vary depending on the size of the employer from 15 to 50, or somewhere in that range is $50,000. It steps up for employers of 500 or more. At the highest cap is 300,000.
Okay.
That's for a combination of non-economic, what's called compensatory and punitive damages. Economic loss is uncapped.
Okay. And my second follow-up, just as to, in reviewing both of them, since you're both all very versed in it, is there a difference where the state law is more stringent than the federal law?
Yes.
And what is that?
The state law does not permit for punitive damages.
So that's more restrictive in the sense of, okay, than the federal law. Okay.
Correct.
I just wanted that comparison as to, because everything that you had given the federal law was like the days that they have, the 300 versus the 180, that it gives a little bit more room.
State law gives a little less time to report, and state law does not allow for a jury, as we've discussed.
Okay.
The standard is going to be the same. The standard for what constitutes sexual harassment, the state law follows the federal law. That's how the courts analyze it.
Okay. I was just looking for that comparison. Thank you.
Federal law is also more stringent on the time that you have once the EEOC divests itself of jurisdiction over your case. It's a shorter amount of time in which to bring your claim to federal court under state law. Once the Pennsylvania Human Relations Commission closes its investigation, you actually have a longer time in which to bring your claim to state court.
All right, and moving on to Representative Topper.
Thank you, Mr. Chairman. Ms. Mangiovi, this question is probably going to require a somewhat subjective answer, so I apologize for that. It just struck me as you were going through some of the highlights, and you mentioned, policies such as, no dating with supervisors, or what I would call like a fraternization policy. And it brought to mind, before even the Me Too movement, we had heard the term the Mike Pence rule concerning the vice president and his policy that he himself had put in place in terms of being alone with members of the opposite sex and things like that. And at the time, I remember hearing, well, that's not giving women the same opportunity in terms of access to him or to public, to be able to change public policy. Of course, we've not heard, too many people criticize the Mike Pence rule recently. Is there any concern as we look at public policy that we are actually moving to limit access for females in certain positions? Are men going to start saying, again, this is a subjective answer, I'm just asking for an opinion, are men going to start saying, well, look, if I've got the option to hire my chief of staff and we've got two people who are the same, I'm going to err on the side of caution and hire a man. We're going to be working together in long hours, evenings, closed door settings. What is your opinion on that? And really, is that even a concern for you?
My recommendation spoke to anti-dating policies, not anti-fraternization policies specifically. As a female in a male-dominated profession for 20 years, if there was a rule that every male couldn't have lunch or dinner with me, I would never have clients or any type of ability to progress in my profession. Business pipelines are often developed and come informally, and I don't believe that we've devolved to the point that we can't sit at lunch together without someone making an appropriate sexual pass at another person. So I would not be in favor of anti-fraternization. I believe that actually enhances the imbalance of power and connections that exist in many professions. There are certain professions where perhaps there are exceptions to that rule, but I would not think it would be yours or mine.
Thank you. Thank you, Mr. Chairman.
Chairman Galloway.
Thank you, Mr. Chairman. I'd like to go back to the comment about innocent till proven guilty and guilty till proven innocent. And I think this is where there is a huge disconnect. And it's probably the first question that's brought up. And I do agree with your statement. I thought it was very, very good. As an investigator, you're talking about as an investigator, someone looking into an allegation. Where does that stop? I mean, at some point, there has to be a clear difference between someone is innocent till proven guilty, right? Yet there are instances where that should not be the case, right? Is that what you're saying?
What I'm saying, Chairman Galloway, is that in most circumstances, the person who is coming forward complaining about harassment in the workplace, especially more egregious harassment in the workplace, is not making it up.
No, I agree with you, but I'm just trying to, like who gets to make that judgment? Like, you as an investigator can say, that's what I'm going to do. I am going to presume, based on my experience, based on everything I've heard, this person is telling the truth. Who is it? A judge? Who can't do that?
That's a good question, Chairman Galloway. That comes from experience, and that's part of an underrated. It's really an underrated part of this process. What Me Too has done is it has collectively gotten the attention of the workplace. It has, I don't know about you, but my workplace harassment trainings this year have gone up markedly. But one thing which hasn't gone up markedly yet, but I suspect will, is how companies can conduct those investigations internally, and training people to, you get experience by doing them, but equipping people with the tools to conduct an investigation. Now, if I conduct an investigation, even as someone who's experienced and done it, and I get it wrong, the person was not telling the truth, and I came to the conclusion that the victim's claim was truthful. At the end of the day, the employer under the law is tasked with taking steps that are reasonably designed to end the harassment. So I will take steps that, I will recommend steps that are reasonably designed. If I get it wrong, the worst thing that could happen is someone who is falsely accused would lose their job. That person generally would have no recourse. But even if I get it wrong the other way, and someone, I come to the conclusion that the facts don't support a complaint of harassment in the workplace, I'm still going to recommend prophylactic steps at the end of the day to make sure that this type of behavior that's complained of doesn't happen again. We'll counsel, we'll reissue the anti-harassment policy to both the victim, to encourage him or her to come forward to complain again, to the person who's accused, reminding them there's no retaliation in the workplace and this is what we expect. And hopefully that will end any issue one way or another. If the behavior stops, if I take reasonable steps that are designed to make it stop, under the law, if we ever get to a courtroom, the employer should prevail.
Thank you. Thank you very much.
Representative Dush.
Thank you, Chairman. I've worked for the Air Force, and it's a large organization that has some exceptional sexual harassment policies, and even at that, we haven't been able to completely stop it. I've also worked for a small company, and when you have the things that what I'm concerned with is going to the point where our largest employer as a unit are small businesses here in Pennsylvania. With the reduction in the number of employees necessary on some of the bills, what do you guys see as some potential issues? Because when you're in something like the Air Force or a large corporation where the person who's ultimately responsible is very far removed from the activity down on the floor, there have to be investigative processes. There are the types of training that go on to establish a corporate culture versus what is necessary for just a small business to be able to stay in business with all the regulations and such we put on them now. What are some of the potential fallbacks or potential issues you guys see with the legislation that's pending?
Well, Larry can certainly speak to the impact that going from 4 to 1 employee may have from the employee rights perspective. I can just say from my, again, anecdotal perspective, I don't represent many employers that have only 5 or 6 employees. Most of my clients in these types of situations satisfy the 15-employee threshold for coverage under Title VII. And for the ones that don't, it's really close. It's really close. So I would be guessing, but making an educated guess, that going from 4 to 1 wouldn't create a spike in harassment claims here in the Commonwealth.
I think, the dynamic between the larger company and the smaller company is such that the larger company, as you said, has the HR person, they have the training in place, they have different levels of management. What we see with the smaller companies is quite often the perpetrator is the owner or is the person, the owner's son or someone in a family. And in those cases, unfortunately, those folks, number one, they're the king of their world. What they say goes, and if you don't want to abide by it, you're out on the street. So, there is protection to a certain extent with some smaller companies, 15 to 20, 25 or what have you, but with the smaller companies, it's, whatever the owner says is going to go. So it's not a matter of training, because the owner should know better. It's a matter of the culture and whether that culture is going to follow the rules voluntarily or involuntarily because there are consequences.
Thank you. Moving on to Representative Cephas.
Thanks, Chairman. I just had a quick follow-up to the Mike Pence rule that was discussed by one of my colleagues. If you begin to see a pattern of that activity as a result of this conversation, would there be another case for discrimination because you are a woman that could be then taken to the Human Relations Commission? And do you, I mean, again, subjective, from your vantage point, do you see this now shifting or potentially shifting into that direction?
Well, I would say absolutely. A woman, sex discrimination is not just discrimination because you're being sexually harassed. It's being given different opportunities in the workplace because of your gender. So I would say absolutely. If a woman can dimension a claim because she's not given the same options and opportunities in the workplace as a man because the boss prefers to hang around with men, whether it's at lunch or after hours, in some sort of off-site setting that the woman's not given access to. And I think, a woman could show that it's materially affecting their ability to succeed in the workplace because of their gender. Yeah.
What you're describing would be a hostile work environment potentially. I do not believe that a segregated workforce is a good workforce. I certainly also would not want there to be a job expectation where a female needs to deliver papers to a male's hotel room at 9 o'clock at night as a job expectation. But I don't believe the way to address that is to enact an anti-fraternization policy, which quite honestly deprives women and people not in a power position of opportunity.
A follow-up question. Based on your practices, what percentage of your cases come from men versus the cases that are filed by women?
From a gender discrimination standpoint,
yeah,
I'd say probably maybe 20% are men, and that includes same sex as well. So sometimes there's male on male or female on female, but I'd say overall maybe 20% is male.
Okay, thank you.
Thank you very much. I appreciate the panel and your expertise and you sharing your expertise with this body. We will be recessing at this time for lunch, and I want to remind members to keep your packets because your testimony for the afternoon panelists are in those packets. The committee will reconvene at 1 p.m. and I want to encourage you to be here promptly at 1 p.m. That will begin with a member panel, a brief member panel just to outline legislation that they've introduced and has been referred to this committee regarding issues as far as workplace harassment and sexual misconduct. And so that's an important start to this afternoon's testimony, and I want to encourage you, please be back promptly at 1 p.m. As you all know, I like to run a tight ship. Thank you all very much. All right, good afternoon. I'm going to call this meeting of the House Labor and Industry Committee back to order. And first order of business this afternoon is inviting some of our colleagues in the House who have introduced legislation on this topic and has been referred to the House Labor and Industry Committee. I'm going to invite them to come forward and give us a very brief synopsis of their legislation. This is not meant to be a debate. It's not, there are going to be no questions, simply so that our members of this committee know what's out there and what's available in our committee. So I'm going to invite, I believe we have Representative Delosier and Representative Oberlander, Representative Margaret Davidson, I believe, has come in the room, and then Representative Maureen Madden. We have 4 seats right up here, and then Representative Leanne Kruger-Branicki is sitting right beside me, and since there's only 4 seats there, I'm going to ask her to do it from up here. We'd like to move this panel along quickly because we have a very limited amount of time, and we'd like each member to keep it to about 2 minutes. So if Representative Davidson, if you'd like to join the folks at the table, and we'll we'll go Representative Delosier, Representative Oberlander, Representative Kruger-Branicki, Representative Madden, and Representative Davidson, in that order, if we can, just to keep it orderly fashion. So, Representative Delosier, if you would like to start out with the synopsis of legislation that you've introduced.
Okay, thank you, Mr. Chairman. I appreciate the opportunity to just quickly give an overview as to what we are trying to do and make some positive changes. Throughout my career in state government, I have witnessed the benefit of gathering information and being able to take a deliberative approach to not only making public policy, but also making legislation. Many times we've been able to take a look at what's good intentions, but also then in the end realize that there were some things that we should have taken into consideration before putting something into law, and then we have to take a couple steps back. So the goal of this is to make sure that we have all information necessary before we move forward. And while harassment should not and cannot be tolerated in the workplace, we need to examine the laws, regulations, and policies that we already have in place. And that was a lot of my questions that were today as to what do we have and why do we have it. And as we've heard from many of the testifiers, we have many things to corral and many things to take a look at. So with many of my colleagues, I'm proud to sponsor the resolution creating a task force on harassment of sexual misconduct in the workplace. This task force would operate in the same manner as the highly successful Child Protection Task Force, which has resulted in 24 new laws to further safeguard our young people. The Harassment and Sexual Misconduct in the Workplace Task Force would be responsible for conducting a comprehensive review of federal, state, and local laws, the regulations that go with them, and policies to unearth inadequacies and provide feedback on a public report to the General Assembly. And I stress the fact that it would be public and we'd be able to share that with everyone. Members of the task force would include human resource professionals, employers, state agencies, as well as victims and service organizations and attorneys. We would be best served by gathering input from all stakeholders. They are the boots on the ground and have extensive experience in the area of employment. The findings and the recommendations would then allow us to move forward with the most appropriate fashion to tackle the issue. Many times we need things to work together versus working against each other. So the ability to have a clean slate is the ability to move the issue forward, I think, in the best way. Before we can take action, we need to know where we are and what steps should be taken, and before we do some form of legislation without knowing what we have. And one of those examples that we mentioned earlier, policy versus law, and the example that I had used with the testimony was the issue of even within the legislative branch, we have 3 separate policies on sexual harassment. It's not a legislative issue, it's not a law, but it is our policy. And so the question comes back as to why. Why do we have 3? Why shouldn't we just have one that goes across the entire branch? So that's something, one small example of something that we need to look at. And as a longtime victims advocate, both through my work in the community and as authors of different pieces of legislation, I understand the anger, frustration, and fear that the victims face. We owe it to the victims to remove barriers and make sure that the most appropriate and effective safeguards are in place. And I'm confident that a task force and the evaluation of what we do have in our state government is the best way to fill the holes that are giving perpetrators the power in our workplace. Thank you, Mr. Chairman.
Thank you, Chairman Kauffman and members of the Labor and Industry Committee. I appreciate the opportunity to be here and participate in today's hearing. As you've already heard, harassment, whether sexual or otherwise, should not be and cannot be tolerated in the workplace. While our own internal policy has been updated to reflect changes in the law and best practices a number of times over the past 2 decades, it is time to review the practices and the policies to deal with this issue within all of state government. I'm going to briefly describe House Resolution 829. And this resolution would require the Joint State Government Commission to study the frequency of harassment and sexual misconduct in the workplace in state government. The Joint State Government Commission will then prepare an analysis of the prevalence and the results of harassment and sexual misconduct complaints. This will include the following: the number of complainants, any disciplinary action taken as a result of the complainant, any complaints referred to law enforcement, and any complaints that resulted in monetary settlements or awards, as well as a comparison of human resources practices and policies for harassment and sexual misconduct for each state agency or entity, and the report will be due in 12 months. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. I want to start by thanking the Majority Chairman for scheduling this important hearing on sexual harassment. April is Sexual Assault Awareness Month, and this is an issue that Pennsylvanians are following closely, especially since news stories of taxpayer-funded sexual harassment claims against legislators started to become public at the end of last year. I'm here today to testify on House Bill 1965, also known as the Me Too Pennsylvania General Assembly Act. Representative Tara Toohill has joined me as a prime co-sponsor on this bill, and we are both working hard to advance this legislation. We currently have 66 co-sponsors, including Republicans and Democrats, and both the majority and minority chairman of this committee have signed on to our bill. While some of the other bills that we're hearing testimony on today focus on issues of sexual harassment in the broader environment, our bill is specifically focused on how we address harassment issues at our state capitol. As we heard from an earlier panel of experts who work with victims and survivors, certain kinds of workplaces have higher rates of sexual harassment, those that are highly male-dominated, those with hierarchical structures, and those with stark power differences. By all those measures, our state capitol is a high-risk workplace for sexual harassment. I started working on this bill 6 months ago after publicly sharing that I am one of the 81% of women who have experienced sexual harassment. But after I shared my own story, women who worked here in this Capitol started to come and share their own stories with me. And I learned that many of the alleged perpetrators were legislators. I heard stories from women who were discouraged from ever filing a complaint in the first place. I heard stories from women who faced retaliation. And I heard stories from women who believed legislators would never be held responsible for their actions. House Bill 1965 is modeled after a federal bill that passed Congress this past February with overwhelming bipartisan support. We then went through 7 drafts of this legislation before it was introduced, with significant changes made based on feedback from Pennsylvania Coalition Against Rape, Women's Law Project, and Pennsylvania Coalition Against Domestic Violence. This bill has shapes by the victim advocates and designed to effect change here. House Bill 1965, in brief, does the following. For the first time, it defines sexual harassment in state statute. It takes the politics out of the process for victims and survivors to file a complaint. Under our current system, there are 4 different policies for 4 different caucuses, and elected caucus leaders ultimately have the final say in how complaints are resolved. This bill creates a new Office of Compliance where trained professionals are in charge of the investigation, not politicians, and creates a clear complaint process for all victims and survivors, no matter which legislative agency they work for. It creates due process for the alleged harasser through a confidential investigation process. It prevents retaliation against an employee who makes a complaint. It creates a provision where, if there is an investigation against an elected official and the complaint is found credible, the elected official can no longer be shielded by a non-disclosure agreement. The victim, though, could still choose to remain anonymous. It creates a new provision where, if there is a violation by an elected official and the resolution includes a settlement payment, the elected official would have to reimburse their state for any settlement award and legal fees. And this models the bill that passed in Congress. And lastly, it creates an ongoing report for the legislature that gives us clear data on the number and nature of complaints filed and how they were resolved. In closing, I'm grateful that this Labor and Industry Committee is making the time to explore this issue, and I'm hoping, Mr. Chairman, that the next step after this hearing will be a vote on these resolutions and bills before us today. We need to change the culture here in the Capitol, and these bills deserve a vote. Thank you.
Thank you, Mr. Chairman. Thank you for the opportunity to testify today. The Me Too movement has awakened us all to the devastating nature of sexual harassment and discrimination that can occur in workplaces across the Commonwealth. My legislation, HB 2280, would ensure that all workers, even in companies with fewer than 4 employees, are safeguarded. Small companies and the employees that are instrumental in making those companies successful are at the heart of Pennsylvania's economy. For far too long, we have left these hardworking employees vulnerable. The idea that any employee would have to be subjected to sexual harassment, discrimination, or intimidation in the workplace is unconscionable. Victims of workplace sexual harassment and discrimination are traumatized and in many cases scarred for life. Currently, the Pennsylvania Human Relations Act treats sexual harassment and discrimination as a form of discrimination based on sex. Unfortunately, the PHRA only applies to employers with 4 or more employees. The definition fails to cover businesses in the state and thereby all businesses in the state, and thereby leaves thousands of employees without legal protections against sexual harassment and discrimination. My legislation will amend the PHRA to say that for instances of discrimination based on sex, an employer is an entity that employs 1 or more persons. According to the 2015 census, there are approximately 153,000 companies with 4 or fewer employees. My legislation will expand protection to include approximately 314,000 more workers across the Commonwealth. The HRC estimates they would need 2 more full-time employees to handle the additional cases at an estimated additional cost of $145,000 annually. Supporting the governor's executive budget proposal for the commission would address any costs arising from HB 2280. Thank you.
Thank you, Mr. Chairman, and thank you, members of the committee. I'm here today in support of legislation, just as I stood with Governor Wolf and fellow legislators and advocates in determining that women need to be safe in their workplace, as well as to combat against workplace discrimination. We have heard countless stories of workplace environments becoming intolerable for the very reasons that bring us here today. I'm here to say enough is enough and time's up. Workplace safety includes creating a culture where every employee feels safe and comfortable going to work. We stand together to say that the culture of discrimination, which includes sexual harassment in working environments, will not be brushed aside any longer, swept under the rug, or tolerated on any level. Sexual harassment is a type of discrimination that may come in many forms, both physical and verbal. Although women are the most noted victims, this issue cuts across gender, economic status, and age groups. Many victims never come forward due to fear of retaliation and fear of not being heard or believed. It is past time to enact legislation that offers protection and allows workers to feel safe enough to come forward sooner. I am sponsoring House Bill 2286, which would update the Human Relations Act to extend the statute of limitations for filing complaints with the Human Relations Commission. We know that many times victims don't feel safe in a period of time which could be years, and we know that from other instances of sexual misconduct and sexual violence. More specifically, House Bill 2286 would extend the statute of limitations for filing a complaint from the 180 days to 2 years. 180 days is simply not enough time for the victim to feel safe enough to come forward and be out of danger, both economic, physical, and emotional. It also includes a right to trial by jury. It would provide that punitive damages and the award of attorney fees would be granted to a prevailing plaintiff. When added to the overall package of bills being discussed today, and my #Time's Up legislation, which also deals with elected officials on every level, not just in the state capitol, because we know that in mayor's offices and council offices, commissioners, there's also sexual harassment taking place. And we need to be able to stand with victims on every level of government, especially when you have perpetrators that cannot be fired. And that is the process for elected officials. Elected officials cannot be terminated, and so victims have to stay in that environment if they are to keep their jobs. When added to all of these bills that we're discussing today, we have a chance to help every working Pennsylvanian giving them the resources to take back their voice and dissuade potential violators, and ensure that victims and survivors would have laws that represent substance in this fight against a volatile workplace environment and keeping people safe and in their workplace, at school environment, and in their homes. Thank you, Mr. Chairman.
Thank you. Representative Rabb, you may go.
Good afternoon. Thank you, Chairman Kauffman, for having this hearing on this timely and vital topic on harassment and sexual misconduct in the workplace. For too long, the influence of sexism, misogyny, patriarchy, and systemic racism have gone unaddressed by our legislature and our society. And it's time we commit to something far more fundamental than symptom chasing, and to encourage employers across the Commonwealth to affirmatively embrace social equity versus simply being reactive to crises born of ignorance, de minimis or ineffectual workplace policies related to sexual misconduct and racial or sexual discrimination. I felt compelled, not just as a legislator, but as a man, to speak up when far too often the issue of sexual misconduct is considered a woman's issue. It's not. It's a gender equity issue. It's a justice issue, which all people have a stake in, despite its disproportionate impact on women and girls. As the descendant of enslaved and unpaid black workers, several of whom were women or girls forced to bear the children of their owners, I am the product of institutional rape. That is the extreme representation of workplace inequity. Practices that were supported by state laws across this nation for generations, policies enacted by state lawmakers who had the power to decide whose safety and very humanity was codified by law. It is in both this historical and current context that I have introduced a bill that I am confident can help several of the problems we face today in the workplace. And I'm proud to have bipartisan support for this bill. The quick outline for House Bill 2282 is as follows. It would include interns as employees in Pennsylvania's non-discrimination protections, and it would ensure that increased training is provided to employees and supervisors, not just with respect to interns, but also about how to prevent discrimination, harassment, and retaliation in the workplace across the board. The bill would require all employers with payrolls of 4 or more workers to provide training for their workforce regarding all forms of discrimination and harassment. I believe that if this were already state law, it could have prevented the racist incident that took place at Starbucks in Philadelphia recently that got national attention. Under this bill, the Pennsylvania Human Relations Commission would develop online interactive training modules that would satisfy these requirements and be available to all employers at no cost. And in the long run, my bill would save money for employers. Think of it as prevention. Spend a smaller amount now on training so you don't have to spend a lot more later on lawsuits and settlements, not to mention all the lost business from public relations damage. We've all seen how Starbucks has been in the news, and no business wants to be in the news because of allegations of discrimination or sexual misconduct. As the saying goes, an ounce of prevention is worth a pound of cure. House Bill 2282 would be a win-win for workers, for customers, for employers, and for the good of our Commonwealth. And I ask for your full support and efforts to help me enact this legislation into law. Thank you.
Thank you very much for all the members who brought their legislation forth today. And in order to keep things moving in a timely fashion, we have our final panel for today's meeting. This panel will focus on the investigatory side of this issue. We'll hear about the PA Human Relations Commission's complaint and investigation processes, the DGS Bureau of Risk Management's claim process, and we'll hear about the best practices for employers who need to conduct an internal investigation. With us today, we have the panel is Michael Hardiman, Acting Executive Director of the PA Human Relations Commission. We have Beverly Hudson, Deputy Secretary of the Department of General Services. And we have Michael Torchia, Managing Member of Siemenoff, Ormsby, Greensburg, and Torchia, LLC. Welcome today. We're glad to have you. If you could each take about 5 minutes and summarize your remarks for us, and then we'll open up to questions from the members of the committee. And you are welcome to go in the order in which I called you up, or if you have an alternate order that you would like, that's fine with me as well. But you may begin.
Thank you, Michael Hardiman.
Thank you.
First, I wanted to thank you for the opportunity to let the Human Relations Commission appear before you and provide testimony. Our focus will be on just what the chair suggested. We will talk about how sexual misconduct can translate into employment discrimination complaints being filed with the Commission, how those complaints are handled, and then finally some of the key points that we believe would assist the General Assembly in understanding how best to approach this subject as we move forward. So let's start with the obvious. The Pennsylvania Human Relations Act prohibits sexual discrimination as well as other types, race, religion, national origin, etc., not only in employment but also with respect to housing, education, and public accommodations. Sexual harassment is a form of sex discrimination under the Pennsylvania Human Relations Act, just as harassment based on any other protected class status is a form of unlawful discrimination. Sexual harassment has been defined to include any unwelcome sexual advances, requests for sexual favors, or other verbal or physical conduct of a sexual nature when submission is either a term or condition of somebody's employment or a basis for employment decisions, and/or when such conduct has the purpose or effect of unreasonably interfering with the ability of an individual to perform their work or creating a hostile or intimidating workplace environment. Sexual harassment comes in two forms: the obvious quid pro quo, the this for that type of harassment, and secondly, the hostile work environment harassment. Harassing conduct can be engaged in either by employees or non-employees in a workplace. Both are actionable under the Pennsylvania Human Relations Act. We have heard much testimony. We have seen it in the news all over that the media is paying significant attention to issues of sexual harassment. Some might be under the impression that as a society we already know this behavior is wrong and that individuals feel safe enough to come forward and to report those experiences. But the testimony and the expert studies that we have seen show this not to be the case. For example, in 2015, the U.S. Equal Employment Opportunity Commission studied sexual harassment in the workplace, and they gathered a task force together to do this. This included outside experts from management of employers, plaintiffs' attorneys, employee advocacy groups, employer advocacy groups, labor representatives, and academics. They discovered that in most cases the target of harassment does not complain or confront the person who is doing the harassment. Rather, instead they choose to avoid them, downplay the gravity, or ignore and endure the behavior. In fact, the most common response to workplace sexual harassment was to turn to one's own family and friends, while the least common was to report or take some kind of action either internally with the company or by filing a formal complaint. Let me just repeat that. The least common response to experiencing sexual harassment is for the employee to report the behavior. According to the study that I just mentioned, only about 30% of the employees were harassed reported the conduct internally. Only 30% of those, 70% chose not to. Even more alarming is estimated that only 6 to 13%, not more than 13%, filed a formal complaint of harassment. That's where we are. And there's good reason that the targets of harassment have chosen not to report their victimizations. Studies also reveal that victims who report sexual harassment are not only met with indifference, victim blaming, and hostility. In addition, 75% face some form of professional retaliation. With their jobs on the line, it's no wonder so many harassment victims choose to remain silent. Let me give you just one more statistic to underscore that last point. Some 27% of the complaints filed with the Pennsylvania Human Relations Commission in the most recent fiscal year, that would be 2016-2017 that's been completed, 27% were retaliation complaints, people who filed complaints because they had previously said something happened to them that was unlawful, and then they believed they were victims of retaliation. That represents the highest percentage of any type of protected class activity complaints that were filed with the Commission. So, for the PHRC, the reality demonstrates why more individuals who believe they have been unlawfully harassed do not tell their employer they were harassed. They're afraid of what might happen to them at work if they do report it, and apparently they have good reason to be afraid. Now, what happens if a complaint is filed? Let me just tell you a little bit about the investigative process. Somebody files a complaint with the Commission. As a previous speaker said, right now, currently the statute provides 180 days, generally speaking, to file a complaint. After filing, the Commission offers the complainant and the respondent an opportunity to participate in a voluntary mediation process. If either party decides not to participate in that voluntary mediation, we begin to conduct the investigation into the allegations found in the complaint. The statutory purpose of every investigation that the Commission engages is to determine whether probable cause exists to credit the allegations found in the complaint. Where the Commission, after it conducting its investigation, concludes that there is insufficient evidence to establish probable cause to credit the allegations, the Commission dismisses the complaint. When it dismisses a complaint, the complaining party has the right to request a preliminary hearing or to request reconsideration of the Commission's action. Under the statute, when complaints are dismissed, or if the Commission has had the case open for 1 year or more and has not issued a decision, the complainant then has the right to file an action in the Court of Common Pleas based upon the protections found in the Pennsylvania Human Relations Act. If the investigation that determines that probable cause exists to credit the allegations, then by statute the parties engage in conciliation, persuasion in order to try and resolve the situation. If that fails, the Commission has statutory authority to convene a public hearing to adjudicate the matter. That's the final step in the process for the Commission. Those decisions made by the Commission are appealable to the Commonwealth Court, but the Commission is serving essentially as a trial court in those situations. Now, let me give you this other statistic. Roughly 35% of the Commission's cases that are filed are resolved during investigation of the complaint. About 35% result in voluntary settlements entered into by the parties during investigation. All right. So after a hearing, I mentioned the adjudication by the Commission determines that an unlawful act has occurred. The Commission issues an order. By statute, in employment cases, the Commission issues a cease and desist order and has the ability to provide additional remedies to the prevailing complainant. In an employment case, that would include lost wages, benefits if they lost a job, a requirement they be rehired, etc. Significantly, though, and I point this out because we had people talking about various proposed amendments to the statute. In only one type of case, the statute currently allows in housing complaints if a complainant prevails at a public hearing. Listen to this. The Commission then has statutory authority to award actual damages, including damages for humiliation and embarrassment. It does not have that authority in employment, in education, or with respect to public accommodations, only with respect to housing cases. Also with respect to housing cases, if a complainant prevails at a public hearing before the Commission may also award a civil penalty in certain cases against the respondent in an amount not to include $10,000 if in fact the respondent has not been adjudicated before as having committed an unlawful practice, and then the statutory penalty goes up, but again, only in housing cases. All right. So what are we going to do? Well, from the Commission's perspective, we start by understanding some of the basics. One, discrimination is bad for employers as well as employees. We know the effects, we know the consequences, how it impacts the workplace on a daily basis. Losses are suffered both by the employer and by the employee. Number two, we know that for the Commission to do its job, its statutorily mandated responsibilities, it must be empowered to fight against the more modern forms of discrimination that are found to exist. We know that the kinds of biases that we see today are not as overt as they used to be or as overt as they were historically. Number three, we know that harassment occurs not just with respect to sex in the workplace, but with all our other protected categories of employment discrimination. And of course, the other reality is that sexual harassment in the workplace is simply a problem that is not just in the workplace, it exists throughout our society. It is reflective of the power-dominant motivation that exists in many, many situations that drives conduct because people believe they can do so because of who they are. Some of the things that we can do have been discussed before: training and prevention, stronger accountability for those who harass. We have to look at this and take this issue seriously because it is not going away. In closing, let me just say this. While we understand that the face of discrimination has changed over time, its consequences for the individual victim as well as for society as a whole has not changed over time. The General Assembly of this Commonwealth recognized those consequences as early as 1955 when it enacted the precursor to the Pennsylvania Human Relations Act, and that was the Pennsylvania Fair Employment Practices Act. This is what the General Assembly said in the findings and declaration section of the statute, talking about discrimination if allowed to exist. Such discrimination foments domestic strife and unrest, threatens the rights and the privileges of the inhabitants of the Commonwealth, and undermines the foundations of a free and democratic state. That's what harassment and discrimination, if allowed to exist, does. That's what the General Assembly said. We urge you to take effective action to limit this as much as possible. Thank you very much for your time.
Good afternoon, Chairman Kauffman, Chairman Galloway, members of the House Labor and Industry Committee, and my fellow panelists, Michael Hardiman and Michael Torsha. My name is Beverly Hudson, and I serve as the Deputy Secretary for Administration for the Department of General Services, DGS. Thank you for the opportunity to appear before you today to discuss the Department's role in administering the program established to ensure consistent application of policy and procedures when an accident or occurrence results in personal injury liability claims against the Commonwealth or its employees, officials, or volunteer workers acting in good faith in furtherance of Commonwealth business. For many individuals watching this hearing, the inclusion of DGS may be less easily understood. So please allow me to begin by explaining the role DGS plays in the Commonwealth. DGS is the Commonwealth agency that provides the facilities, equipment, goods, and services that make it possible for other government agencies, our direct customers, to serve all Pennsylvanians. As one of its responsibilities, DGS, through the Bureau of Risk and Insurance Management, or BRIM, manages and administers a myriad of self-insurance, excess insurance, and specialized insurance programs on behalf of the Commonwealth. One of the self-insurance funds BRIM manages is the Employee Liability Self-Insurance Program, or LSIP. LSIP is the self-insurance fund used to pay settlements or judgments and related expenses against the state and its employees for claims of personal injury resulting from negligence, employment discrimination, wrongful discharge, sexual harassment, assault, false arrest, defamation, invasion of privacy, errors and omissions, or violation of any other civil rights. Attached to my testimony is a table that summarizes the fiscal year 16-17 billing and claims paid on behalf of the 86 agencies and entities participating in the LSIP. DGS's role in the LSIP claim process is limited to administering payments of expenses, such as court reporting and/or filing fees, settlements or judgments upon the request of agency chief counsel or the Office of the Attorney General in accordance with Management Directive 630.2, reporting of employee liability self-insurance program claims. As such, any questions you may have relative to investigating claims, training on recognizing harassment and preventing it, or any other human resource issues are under the purview of the Office of Administration and should be directed to them after the hearing, and I'm happy to take those questions back to them if needed. For your further information, I will provide an overview of the process used when a request for LSIP coverage is submitted as detailed in Management Directive 630.2. And I would like to add, just as a process point, that the administration is currently updating that directive. It's routing through the approval process. And the process I'm going to share with you today is the process as reflected in that new directive. Agency or entity offices of chief counsel or the Office of the Attorney General, if representing the agency or entity, must submit to DGS a notice of potential claim and request for LSIP coverage. This request must include a copy of the claim, whether it's a civil suit, PHRC, or EEOC complaint, or other formal documentation of the claim or potential claim. A copy of representation letters provided to all Commonwealth employees, officials, or volunteer workers, and an estimate of the potential financial liability of the claim. DGS then reviews the submitted materials to verify LSIP eligibility. If the claim is LSIP eligible, DGS opens a claim file. Agency or entity offices of chief counsel or the Attorney General, if representing the agency or entity, may submit requests for payment of expenses associated with the claims determined eligible for LSIP coverage as they are received. The request must include copies of invoices or receipts, along with sufficient information for DGS to associate the expenses to the LSIP claim file. Upon judgment or settlement of the matter underlying the claim, agency or entity offices of chief counsel or the OAG, if representing the agency or entity, will submit a request for payment of the judgment or settlement. The request must include a completed and fully executed request for LSIP payment of completed claim and a copy of the judgment or settlement agreement. DGS tracks the payment of all LSIP claim expenses for purposes of agency and entity loss history. Unless an exception is made in accordance with policy, LSIP coverage for claims and associated expenses during the life of the case is limited to $250,000 per occurrence. If the total judgment or settlement costs, along with paid expenses, exceed $250,000, DGS will issue payment of the total judgment or settlement and will then issue an invoice to the agency or entity office of chief counsel for all amounts in excess of $250,000. Funds not expended for claims or related expenses within a fiscal year remain in the fund at the end of the fiscal year. Agency and entity billings are based upon a triangulated review of all participating agencies and entities' 10-year loss history as prepared by DGS, along with calculations reflecting each agency's or entity's current year full-time complement and a third-party actuarial projection for the program. The LSIP self-insurance fund billing, along with the third-party actuarial report, are reviewed annually as part of the Commonwealth's annual financial report preparation. With that, I thank you for the opportunity to appear today, and I'm happy to take your questions on LSIP and the process used by DGS to make payments from the LSIP self-insurance program.
Thank you. Good afternoon. Thank you for inviting me here today to the committee to provide information about workplace investigations. My name is Mike Torsha. I've been a labor and employment attorney for 27 years, and I've conducted workplace investigations for private and public employees. I write often on this topic of workplace investigations. I've served as an expert witness on workplace investigations and have been hired to train other investigators. Investigations of workplace complaints is one small slice of a sexual harassment claim in the life of a sexual harassment claim. They are commonplace across the Commonwealth and the country, and whether to investigate and how to investigate in most cases is something that an employer must decide as soon as a complaint is made. The complaints, as you know, can come from any source. A workplace investigation can begin from any source. It can start from the victim himself or herself. A third party can make a complaint. For example, an employee's A colleague can make a complaint that might start a complaint. A manager or supervisor might see a complaint that may trigger an investigation. Sometimes an investigation isn't triggered until an attorney sends a demand letter or there is a complaint filed with the Human Relations Commission, or sometimes even a lawsuit. Sometimes the employer doesn't even know about it until a lawsuit is filed under certain circumstances. But employers, both public and private, have the responsibility to be proactive when a complaint is made. That's the point of a workplace investigation. The law requires employees generally to be proactive and to root out sexual harassment, not be reactive and wait until a complaint is made. So that means that employers need to have policies in place about not only prohibiting sexual harassment and discrimination and retaliation, but also provide training and education and be prepared to investigate when a complaint is actually made. The policies need to be clear about how an employee actually makes a complaint. Any employer must also think about when a complaint is made, who is going to investigate. The requirement to investigate doesn't come from any statute. You can't look at a law that says if you don't investigate, you are in violation of a statute. But it comes from a long line of cases, including 2 U.S. Supreme Court cases in 1998, that make it clear that employers are liable if they don't take prompt and thorough action to investigate a claim of harassment. So one of the primary decisions an employer has to make is, will there be an investigator from inside the employer, from inside the company or the entity, or from outside? And there are pros and cons of each. There are many factors, including whether or not that investigator will be neutral, whether the employer wants the investigator to be neutral, the cost, the speed with which an investigator can begin. Sometimes there is a delay. And whether the communications with the investigator will be private and privileged. If there's an outside investigator, an independent investigator, those communications are not privileged. In other words, if it ended up in a lawsuit, the court would be able to discover the communications between the investigator and the employer and the investigator and anyone else involved. So there's no bright line test about what is a prompt investigation or what is a thorough investigation, although I will tell you there are a variety of cases that criticize investigations that are not done as the court would see it in a prompt way or in a thorough way. This could include investigators who are inexperienced, who don't take measures to review all the documents or interview all the relevant people. The mechanics of the investigation can get a little lengthy, which I won't go through here. I've attached to my materials a chapter on workplace investigations that go through in detail the mechanics of the investigation. But generally speaking, an investigator will interview the complainant first. That makes sense. Get the facts, figure out what it is the person is complaining about. Then all of the relevant witnesses, start to gather documents and other information, and then towards the end of that process, interview the alleged harasser. And I believe it's important to confront the alleged harasser with everything that's been said about him or her. So in other words, if there are 7 allegations, tell the harasser 7 allegations and let the harasser admit or deny or explain away those allegations. And then very often it is important to circle back with the complainant and ask the complainant some follow-up questions of things that the investigator didn't know. It's very common for the investigator to write a report and give that to the employer, listing the facts of the investigation. It is not common, however, for an investigator to be a decision maker. Normally, the investigator is a fact finder and does not make a decision about what should happen with discipline. So it's a nice position at times for the investigator to go in and say, I need to ask you questions, I need to ask you questions, I'm going to write a report, but I'm not going to be deciding what happens if there's discipline here or not. That's not to say that the investigator doesn't make credibility determinations. They often do decide if someone is more credible than not, but they will generally not be the decision maker. The investigators, and I speak to lots of investigators, and I'm also a member of a national organization of workplace investigators. One of the very popular topics now being debated is so-called due process for the harasser. We know that we investigate these claims to make sure that the victim is telling the truth and to what extent these claims are factually accurate. But we've actually read some articles and heard from some sources that the victims should be taken at face value. Why would you question a victim? Why would they lie, etc.? The answer is, I don't know why any victim would lie. I don't know why someone would make up claims or why someone would wait. But from the investigator's standpoint, it's not for us to prejudge. So I believe it's important to give so-called due process to everyone involved, including the alleged harasser, and only that way can the employer determine what remedial measures should be taken, if any. There's no legal requirement for due process. You know, we talk about due process like in a court of law, but it is a matter of fundamental fairness to give everyone an opportunity to explain the story and what happened. So essentially, the investigator needs time and opportunity to interview witnesses, review documents, maybe video, any other information that is out there, provide a factually accurate report to the employer so they can determine what remedial steps to take. And again, I've provided some materials that go through the mechanics in some detail, as well as giving the legal basis for the investigations. So with that, I'll conclude my initial remarks. And again, I appreciate the opportunity to provide information here today. Thank you.
Thank you. And starting out, Representative Kruger-Branicki.
Thank you, Mr. Chairman. My questions are for Deputy Secretary Hudson. I, like a lot of legislators, first learned that we had an employee liability self-insurance program by reading about it in the newspaper. So I've got some questions for you about how this program works. So first of all, in the appendix, you include agency billing for fiscal year 16-17 totaling $5.7 million and agency claims totaling just over $3 million. Is that for all claims or specifically for sexual harassment?
That is all claims in the program.
Do you have any idea what the breakdown is only for sexual harassment claims?
I do not. BRIM, in its role, as I mentioned in my testimony document, this self-insurance program covers a myriad of civil rights actions. We do not categorize them further than identifying them as part of the LSIP program.
And which agency would be able to break down which of these claims were specifically related to sexual harassment?
So that is a discussion that is happening with the administration in coordination with the Office of General Counsel, the Office of the Attorney General, and agency chief counsels, how best to collect that information.
Okay, so we're not currently collecting it.
We are not categorizing those claims.
Okay. And then what are the factors that actually determine whether these claims are eligible to submit?
Certainly. From a BRIM perspective, as I mentioned, we do administer a variety of self-insurance programs. Our review as it relates to eligibility is simply that it is in the right self-insurance program. Okay. So the other large program we administer is the ALSIP program, which is automotive liability, which is a much larger program. So our determination of eligibility is just that it's in the right bucket of insurance.
Okay, so it's really up to the agency or the entity to determine, yes, this is an eligible claim, and then to submit it to you. You're not making any kind of judgments on those claims.
That's correct, and I believe the agencies and entities are doing that through their offices of chief counsel and or the Attorney General's office if they're representing the agency or entity.
Okay, thank you.
Certainly.
Representative Delosier.
Thank you, Mr. Chairman, and I actually will go along with that because I also had some questions. So the agency billing, this is 86 agencies, as you mentioned in your testimony. I'm noticing the ones that are in here, there's independent agencies as well as executive branch agencies. What determines who's in them and how does the money in the fund get there? What does each pay a certain amount? If so, what is that? How do they determine that? And what if they use more than they've put in?
Certainly. So as I indicated in my testimony, there is a comprehensive process used to determine every participating agency's and entity's portion of the shared services billing. The fund was established in 1975. I can tell you today when we establish new insurance programs, we go out to agencies under the governor's jurisdiction as well as independent agencies, the House and Senate, because again, by aggregating that spend, it reduces the premium costs for everyone. I can tell you people do come in and out of certain insurance programs, but the decisions to participate are the decisions of those agencies and entities.
And I don't notice, well, you have one line, and is this all encompassing the entire judicial branch is encompassed in the judicial system?
That's correct.
Line item. So that is also not broken down necessarily as to what courts or what level of court or?
I do not believe so, but I'm happy to follow up and confirm
Okay,
that answer.
that was the only one that mentioned, I was looking for the 3 branches is really what I was looking, that all of them were included or not. And my last question is, the dollars that are put in, so they come from the GGO of that particular agency into this fund? I mean, granted, the state is self-funded, and I recognize that. So, but aging puts in their percentage from their GGO. I'm looking for the line item.
Yeah, I wouldn't be able to speculate any agencies other than my own, but I can tell you DGS uses GGO funding to pay its portion of the bill.
And percentage to DGS's budget, what percentage goes into the fund from DGS to get an idea as to what a state agency pays?
Can you ask that question again? I'm sorry.
DGS is a fairly large state agency, relative. I mean, it's not transportation, but just to get an idea, the GGO is X. How much of that percentage GGO goes to this fund?
It would be a very small proportion in DGS.
Well, that's what I'm just trying to understand how much they actually put, give or take.
Our general budget is just under $200 million, and our portion is listed on here. For LSIP is $16,925.
Oh, okay, so I'm sorry, I misunderstood how to read the across the thing. Okay, so this is what the agencies actually put in.
That's correct.
I'm sorry, I misunderstood that.
The
Okay.
first column on the left is what agencies are billed
Okay,
for the
sorry, I
premium,
gotcha.
and column on the right is what was paid out in that fiscal year.
Okay, I apologize, I missed that. Okay, so and then it's just their decision as to whether or not to participate.
That's correct.
And what if they would get a claim and they are not a participant?
They would be paying that out of their operating dollars.
Okay, it's their choice as to whether or not.
Correct.
Okay, thank you very much.
It would be their choice as to how they.
Well, right, how they handled it. Okay, thank you very much.
Certainly. Thank you for the question.
Thank you. Moving on to Representative Cephas.
Thank you. I have questions in reference to the investigator community that you guys talked about. Are you seeing any, and you mentioned it in your testimony, and I specifically want to ask questions about college campuses. Have you seen trends as it relates to, again, due process when it comes to the accuser on college campuses when it comes to sexual harassment claims? And if so, how is your community responding to make sure the accusers aren't kind of going back and making additional financial claims against them to make sure things are really streamlined across the entire process to make sure that there's due process when it comes to the accuser and the victim?
So I think that in this environment especially, there has been a real increased sensitivity to giving the, did you say the accuser, right?
Mm-hmm.
The alleged victim, right? To giving the alleged victim, due process to make sure that those complaints are being investigated. I think the mistake that's been made historically for many years is people who the accuser complains to don't take appropriate action. Mm-hmm. They don't know that they're supposed to take action, or they don't care, or they haven't been trained on the sensitivity of this. So we've seen everything from accusers telling someone about some act or some complaint and saying, well, I don't want to get that person in trouble, so let's just keep it under our hat for now, and I'll let you know if it gets any worse. Now we train managers and supervisors to say, no, I can't do that. I need to take that to the next level. And that's whether it's a college campus or anywhere else. So I think generally people are getting better at that, at being sensitive to the fact that a complaint is a complaint and we need to act on it. To the second part of your question, to make sure that people don't come back and complain again, there are two parts of that. First of all, sometimes accusers will come back and say, I have an additional complaint, either because something else happens, there is another incident, or they're hesitant to tell the whole story the first time, and they don't trust the process. Sometimes they're maybe correct of not trusting the process. and they will say that, you know, there was an incident, but they don't want to disclose the entire incident. I had an investigation 7 or 8 years ago in Michigan where a woman was complaining about the president of the company. I interviewed her for hours, and she told me about all these things that he did, and something didn't really add up. I went back to her a second day, and we spoke at length, where she divulged that there was actually a sexual assault that didn't come up at all during, you know, many hours of the first talk. So those sorts of things do happen. And then, of course, there's the issue of non-disclosure agreements, which I don't know if you want to get into, but those are, that's, you know, very, very complicated subject these days about confidentiality and whether or not victims should be bound by them.
Okay. So. Can you briefly just speak to the individual being accused? Has there been a lot of conversation around ensuring that they feel as though that they receive due process as well?
I think, yes. I mean, I think as people get more sensitive about investigating complaints that are brought by alleged victims, that goes hand in hand with making sure that the alleged harassers get due process. And again, in this environment, in the last year or so with the Me Too movement, everyone is very maybe hypersensitive to giving the alleged harasser due process and letting him or her, you know, as I said, tell the story, admit it, deny it, explain it. You know, sometimes we forget, and now in the Me Too movement, it's usually women who are harassed by men, but that's not the reality of what happens out there all the time. You know, women are harassed by women, men are harassed by women, men are harassed by men, so it's really a wide variety of claims. It's not always, you know, a female victim and a male harasser, although that's still probably the most frequent that, you know, by percentage. So I think everyone's sensitivity is raising.
Thank you.
Representative Dush.
Thank you, Chairman. Deputy Secretary Hudson, I have a feeling I know the answer to this, but I want to clarify it. The Department of Corrections numbers on your appendix, does that include PREA, or is that the Prison Rape Elimination Act, or is that just staff or employees on employees?
I'm not aware of the acronym you just shared, so I believe it's just their employee liability.
All right. Second, the posting of employees' rights, usually they have to be posted, and I was just curious, I know public sector employees, we do have some of the sexual harassment, employee right kind of things. Does that also apply in the private sector? Do you know under the current statutes?
I know. Mr. Hardeman would know too. Yeah, yes, there is a if you're talking about posters to yes. Post rights, yes, there is a requirement, a state and federal requirement to post employee rights in a conspicuous place so that employees know their rights under state and federal law. And there are some little quirks about employees that work remotely and how you get them noticed. But basically, yes, there are poster requirements. Most employers that I know, without mentioning any company names, will literally call a company that provides human resources posters and pay $70 or $80 for a big laminated poster and, you know, stick it up in the lunchroom or someplace like that. So.
And Mr. Hardeman, do you guys have a public relations thing out there in order to try and get that kind of information out to where the general public is actually aware that these things?
We do, and we do that, first of all, on the Commission's website, which has all of that information is provided, including the requirement under the statute to have that notice posted. We also conduct training sessions across the Commonwealth to let people know what their rights are and what their responsibilities are.
It might be a good idea to try and get that so that whenever somebody Googles that in the Commonwealth of Pennsylvania, that it's one of the top rated hits, so that the people actually are very quickly aware of that. Great I think idea. That might be a good way to go for the Commission.
Thank you for that.
And lastly, having been an investigator as well as a supervisor, it's actually had to handle a couple of these things. Back in the 80s, we didn't have the type of policies in place with the Air Force that we do now. But when you do have a false claim, which is one of the things I dealt with back then, it was as a supervisor, you were the one that did the investigation, the initial investigation, And in this case, the woman forgot the fact that there was actually recording, so she quickly ended up dropping the situation. But then there are others where the investigators right now, I want to just, from your perspective, Mr. Torchia, are there, with the Me Too movement, is there pressure to lean more towards one side or the other as a result of this? That tainting the investigation is my big thing. If we're going to do this, the best thing, like you said, having the investigator separate from the decision-making process is a very important step. But I just want to make sure that, from your professional experience, we're not seeing public pressure influence, rather the facts.
Right. I have not. I have not seen public pressure to lean one way or the other. Those of us who conduct independent investigations take our job very seriously, that we're independent. It's also interesting, too, that very often from the claimant side or the plaintiff or the employee side, the investigated community, we're often accused of being really just hired by the employer, of course, because we are hired by the employer or the employer's attorneys, so they think that we're biased for the employer. But you might be surprised at how often the employer is rooting for an investigation that shows that the employee actually did something wrong. There are many times there are internal political issues where they can't terminate someone or take discipline against an employee, but armed with a report from an investigator, an independent third party, they can go and they say, okay, now we can suspend that person, now we can terminate that person. So the point is, going into an investigation, I rarely know which way, quote unquote, the employer would like it to turn out. I always know which way the victim would like it to turn out, but I rarely can really figure out in the beginning how the employer wants it to turn out.
Well, having been a private investigator before doing defense work, I understand where you're coming from, and that's one of the things I want to make sure we were still keeping a kind of a separation there, so that it's down to the facts rather than political pressure.
Any bias, right?
Thank you.
Thank you.
Thank you, Representative Menser.
Thank you, Mr. Chair. My question is for the Deputy Secretary. Does LSIP have a reserve?
Not a specific reserve, no. So as I mentioned in my testimony, if there are funds remaining in the fund at the end of the fiscal year, those funds do roll over and remain in the fund.
So, for instance, in 16-17, there would have been about $2 million.
Correct.
Thank you. So you do have a reserve. Thank you.
And Representative Topper.
Thank you, Mr. Chairman. Mr. Hardiman, we've heard a wide range of what would classify workplace harassment, sexual misconduct, sexual harassment, anything from areas that can obviously be gray and subject to a lens of different facts from different perspectives, to downright sexual assault and rape, which is, of course, there's no lens for that at all. What are the most common workplace harassment, sexual misconduct complaints that you field? In other words, as public policy makers, what is our largest area that you guys deal with? Is there any way that can be broken down?
It would be difficult to do so with real precision, I think, because there are frequently within any given complaint a variety of actions that may have occurred. Obviously, the kinds of physical assault, rapes, those in the workplace are not that common.
What about the quid? You mentioned the quid pro quo, very early on, kind of the most basic form that we think about in terms of.
Want this, you have to do that.
Right. I mean, are we talking a really large percentage?
I don't know the percentage of that we're talking about. It's certainly not the majority of the complaints that we see filed with the Commission. It is, as I said in part of my testimony, the face of discrimination is changing. It's not as overt as it used to be because people understand they can't act as overtly as they used to be. They have to exert that power in a different way. So it doesn't represent the overwhelming majority of complaints that we get, no.
You know, just to comment on that, as lawmakers, we like to, we like to see a problem and have a law that can fix it.
Yep.
Like that's why we want to, that's why we're here.
Yep.
In many cases. And so to try and grapple with something that seems to be as loose as water sometimes, it can be difficult to get fixed on what can we actually do. So just if you were king for one day and you could say this would make, knowing that it wouldn't fix everything, but that this would from your perspective be the absolute best fix for what you see in terms of the complaints, what would that be?
Well, thanks for that question. Oh, yeah. The best thing. Boy, see, here's what as you point out, what we're dealing with is what motivates somebody to act, because that's what you have to demonstrate most frequently to find discrimination under the Human Relations Act. What was the motive behind what you do? I think perhaps the most obvious first step is to make the punishment, that is to say the remedy, so significant that it encourages those in charge, the employers or their managers, to reduce as much as they can the possibility of somebody misusing their power in the workplace. Do you know what I mean? If the worse the consequence is, the more likely you are to get employers to say, wait a minute, the easier way to do this is to begin to train our employees. The easier way to do this is to make sure that everybody understands what can happen to them if they engage in this type of behavior, because that reduces our risk, that reduces our cost. It's like any other cost for business. So that's where I would go with that.
Right. All right, perfect. Thank you. Thank you, Mr. Chairman.
Thank you very much to the panel. I appreciate your expertise in coming here today. I also want to note that in the legislator panel, there were 2 members who submitted written testimony, and that is Representative Mike O'Brien and on House Bill 2284 and Representative Dom Costa on House Bill 2283. So with that, I thank the members for their attention today, as well as everyone who testified. I appreciate your expertise. We have all big issues to deal with on all things, but especially on this topic. And so I thank you very much. And we've stayed pretty much on time. And with that, this meeting of the House Labor and Industry Committee stands adjourned. Thank you.
Thank you.
Thank you, Mr. Chairman.